All right, well, good morning to everyone that's here in the room and everyone that's joining us via Zoom. Welcome to our Official Commission on Mental Health May Commissioners. All right, well, good morning to everyone that's here in the room and everyone that's joining us via Zoom. Welcome to our Official Commission on Mental Health May Commissioners. All right, well, good morning to everyone that's here in the room and everyone that's joining us via Zoom. Welcome to we're going to talk about the work of the commission that's been done since the last time we met, and it's a lot. We have provided technical assistance, and including a sim mapping workshop that took place, and we've worked on various guides for mental health courts. We are working on proposals for the upcoming legislative session on the legislative committee, and we have registration for the 2022 summit now open. So I encourage you, everyone who is a commissioner and on the collaborative council, to go ahead and sign up. Because if it's like earlier years, it will sell out. You should all have a copy of our meeting notebook if you're here in person. It looks like that. If you have any questions or any concerns, please, we have a lot of JCMH staff here that I think Christy is going to introduce and talk a little bit about what everyone staff is doing later on. But if you need anything, please feel free to reach out to them. And now, my co-chair, Jen Hervey, founder of this commission, as please announce.
Thank you, Justice Plant, and good morning. It's wonderful to bring all our commissioners to Austin. It's been a while. And some for the first time we've been appointed because we have so little time together in person, we're going to extend your terms for one more year unless you hate us. Long-term planning committee met yesterday to put together our new strategic plan. The executive committee looks forward to reviewing their work, receiving it, and then sharing the new strategic plan with commissioners for comments. Next, I'd like to introduce our newest collaborative council members. The council is a tremendous asset to the commission and helps share information about issues that affect judicial and court practices involving persons with mental illness or IDP. New members, after I say your name and short bio, please feel free to stand up and say hello to the commission if you are here. Our newest members, Jen Freer is the DBT or dialectical, that sounds interesting, behavior therapy implementation leader for the Texas Juvenile Justice Department. She is planning to hear. Oh, okay. Sorry. Shannon Hoffman is policy program specialist for the Hogg Foundation for Health, assisting the policy unit and providing education on mental health topics to elected officials, advocates, state agencies, and other stakeholders. We are thrilled to have them with us. Please take a moment to welcome them today. The council will meet 3 times this year. We had our first meeting on March 1st, where we asked members to bring innovations happening within their organization. We looked at the new JCMH innovations map and encouraged members to add what their communities are doing to this list of mental health resources throughout the state. Our next collaborative council meeting is June 6th, and the final meeting of the year is October 3rd during the noon lunch hour. In tab 1, you'll find the agenda for our meeting today. Our next planned break is at noon. Feel free to take breaks whenever you need. Usually we set aside time during the meeting for commissioner updates, but we're trying a new format during the meeting today, and where we alternate commissioner updates and education on a certain topic. This meeting, we are putting the focus on mental health of children and youth, and we'll hear from Judge Renee Rodriguez-Benford and Dr. Scott Report. Afterwards, we'll have a little bit of time for Commissioner and Collaborative Council announcements. Some of you have already emailed your announcements, but if you have not, please write your announcements on one of the provided cards at the registration table during lunch. Next, we have an update from the Office of Court Administration.
And Judge Megan is currently at the Judicial Council and is asked to speak after me.
Okay, and so we will turn this over to Kristen.
So good morning. It's so great to see all of you, and some of you for the first time in person. We are excited. You can tell we have lots of materials to share with you in our meeting notebook. Tab 4, which is really divided by paper. I think there's been a run on tabs, like many other things right now. We have our report to the commission. A summary of all of our work, all of our committees, and the updates. So if you are interested, collaborative council members, commissioners, and what other committees are doing, you would like to get involved in something else, this is a great place to go. I also want to draw your attention to our biennial report. We're very excited. Rose, communications manager, here, put this together for us, and I'm really excited and proud of it. You will likely see many of your faces, and this great story about what we're trying to do. So if you do this every other year, and if you ever have ideas, one really special part is the past. We have a letter written by section to the late Dr. Woodson as all the Okay, and actually now we're going to go to those I just want to thank all of you for this. I know I'm emailing a lot of you to get some something else really special is we have highlighted all of our errors and that and why they dedicate their time to the commission and step up into those leadership positions. So thank you all for that. We're really excited about it. There's also a digital copy that you can have and share if you'd like. And I also wanted to draw your attention to the back of the meeting notebook, which has all of our social media channels. It should be on the back cover. So all of the little icons, those are all of our social media channels. So if you just take your phone and scan the little QR code, it should pop up with our accounts and you can just click follow. So on there, typically we share just different resources and innovations that different communities are have going on, or things that we're doing that we want to share with you. So I'm always looking for things to share. A lot of things I get just through different news articles and finding them that way. But if you have things that your organizations are doing specifically that you would like to share with everyone else, please email me. We love to see what you're doing and share with everyone else so that we can get different ideas from other people in different parts of the state. So always open to ideas for that, and that's a good place to just find different resources. So thank you. I'll hand it back to Christy. Thanks. So I want to take a minute to recognize the awesome work that the staff is doing soon. Glad they're here, and I hope you get a chance to meet them and talk about your ideas. All of our staff attorneys have areas of specialty that they focus on, as well as staffing other subcommittees. So there's a lot to go. Something that they have been doing recently is speaking in other organizations. And so this is something that was well and very proud of. Like topic. That will be that person. A lot of times people ask about that expertise from your perspective. And so recently, February, Dr. Holly Davis spoke at the Juvenile Law Conference. Spoke about Chapter 55 and that the juvenile bench book that she authored. In April, Liz Gibbons was here. She spoke at Texas JCMH Specialty Court. She moderated issued this step guide to mental health care. And then just a few weeks ago, the Harris spoke at the Association of Pre-Trial Services, and Judge Huff and Philip Gonzalez and Mama. There were several familiar faces on that panel. They did a great job and got a lot of good questions and feedback and really making new connections for the commission. We also had the opportunity a few weeks ago to assist with the planning of the conference of chief justices. You've heard about it before, but we had the southern region, which was about 15 states, and then Mexico and the Virgin Islands and Nevada, and a few that had missed their region joined in. And so this was a combination of just not only the conference of chief justices, but the conference of state court administrators. And they focused on mental health and the court's response to mental health. And so it was a great time for Texas to really showcase what we've been doing. I believe, we're one of the only states that has a commission that's permanent, that is year-round, and is this comprehensive. And so we had a lot of questions, a lot of opportunities to share our work, and then we also got to hear from the other states about their ideas. But a lot of the other states were just at the starting place of let's plan a summit, our first summit. Let's talk about how we develop a commission. And so it was good to know that Texas is leading the nation in that. Thank you. Okay, so yes.
On that, I you saw the National Center for State Courts did a 5 or 6 minute video about that and sent it out.
Yes.
Was it you, Rose?
Yes. Well, you just queued it up, so we were good.
Oh, wonderful.
Yes.
I'm on their email distribution list. I got to see it earlier this week. It was great.
Yes, so Rose made that video, and it's such an asset to have that ability to capture the moment. We're going to play that for you. It's a very short video.
I'm excited to be here at this conference that we are looking into issues of mental health and the court system and how we as judges can do a better job of making sure that we are addressing mental health illnesses with the clients that we serve in a very holistic kind of manner.
You know, one of the biggest challenges facing justice systems all across our country and our world for that matter, but in our country, are individuals who are involved in the justice system who have mental health issues. And judges for decades now have struggled with what to do, and other justice system stakeholders have struggled with how to address those needs of those individuals to perhaps divert them out of the criminal justice system.
The biggest benefit is communication and collaborating across states, collaborating within our states. Oftentimes, many of us have never worked with the Department of Mental Health or local people involved in the mental health arena. And so communication is what I think we get most from these collaborations.
My name is Steve Leifman. I'm a judge from Miami-Dade County, Florida. I had the honor of kicking off the presentation this morning, and really it was a compilation of 22 years of work in this field. And it really started from a case that I had in court where I had a Harvard-educated psychiatrist as a defendant who had a late onset of schizophrenia end up in front of me in the criminal division. And it really was, it was a window to everything that was wrong with our criminal justice and mental health system. And as a result of this one case, we had our own summit in Miami-Dade County, where we put together a collaborative agreement where we totally changed the structure of how we were handling things. And we put together a two-part approach, a pre and post-arrest diversion system that has now evolved into this enterprise with a staff of 25 people, a significant budget, but more importantly, it has accomplished more than we ever imagined it could do.
In the United States, in each of our states, the largest mental facility are jails, unfortunately. There are more people in jails who have mental health issues than are actually in actual facilities meant to house individuals who have mental illness. One of the things that the judiciary is really good at is convening people together in a way to really try to come up with solutions to that.
I was on a panel that really focused on children with mental illnesses as a juvenile court judge, particularly those in our underprivileged neighborhoods, our Black and brown youth particularly, and how we can make a difference in their lives. It is super important for us to reach the children before they enter the system. There are so many studies that talk about once a child enters into the system, then there's more likelihood that they're going to stay in the system. And we don't want that.
I am hoping to be able to replicate what we are doing at this summit, and we've already begun discussing that. We've already begun brainstorming who can be at the table. I know the Virgin Isles, they brought a large contingent, including the Attorney General, legislators. Those are the types of folks that we would like to get at the table in South Carolina, and the summit tells us it's possible.
You know, the National Center for State Courts and the Conference of Chief Justices and the Conference of State Court Administrators really recognize this as an issue of national importance to the judicial branch, and so really brought together the leaders from all of those organizations to really think about how can we best address this.
I've learned a lot, and I'm excited about the information that I've learned and ready to go back as our team to make better plans for how we deal with mental illnesses within the court system.
I truly believe that in about 10 years we're going to look back and first shake our heads at how did we ever treat people this horribly, but equally, if not more importantly, we'll have looked back and said, wow, we really fixed a big problem. And I think this is the beginning of seeing that happen.
Thank you, Rose. You can imagine the possibilities that we have with video. We're thinking about creating video libraries with short segments on a specific topic.
I'm so excited to have the privilege of introducing our next panel, Staff with Integral Care, which is the local mental health authority.
And I also wanted to recognize Dr. Keller and the Meadows Mental Health Policy Institute sponsored the evening before and were contributors to making the event really lovely. And that was Dr. Moore, I believe. Yeah, it was Dr. Moore from the Hackett Center. Yes, yes. So it was very much a group effort. Okay, so next on our agenda, we are going to hear from Patrick Passmore, our financial manager.
So we start with budget. That's going to be a notebook on section 6. Give us financial status, where we're at. Down there at the very bottom table, you'll see that we last row, you'll see that so we're on track. So we got if for some reason one of our grantees spends all the money, we do have the ability for the legislature to have those funds forward. So we cover just a highlight of our grants and some progress that's been made on it. I'll start out. But should you all have a chance to look at that, coordinator pilot project, stakeholders, pilot program to measure success and on the 17th, JCMH, HHSC staff, discuss the evaluators, and other this address the project's plan and details and responsibilities. The next steps in the evaluation this project, this process is going to start understanding that this is going to all which we're looking at the next commission. She's the program manager for this. Next is our technology equipment plan for fiscal year 2022. The JCMH Board of Office of Administration grant not to exceed $65 to provide 8 seconds. This application is approved with consultation based on needs and investing in the application and purchase. Those statements are to be all some more updates on towards the solution.
Great, thank you, Patrick. So in March, I believe almost our entire staff traveled to Denton County to put on our first sequential intercept mapping workshop. And I don't see Lee Pearson, but he co-facilitated with me. So we would like to thank him for that. He said that doing it the first time felt like a trial, and that's a big ask for a volunteer, just because it was new and different. But of course, he was fabulous. And we also would like to thank Judge Jan, who was unable to be here, and Judge Ramsey for hosting us, and Judge Chance Oliver. So Molly Davis on our staff is going to give us an update of our sequential intercept mapping.
Christy, good morning, everyone. As Christy mentioned, in March, we went to Denton County, which is one of our Virgin Coordinator pilot counties, for a 2-day mapping workshop. We had a great conversation there, a very interesting conversation. We brought together leaders from the county from all points on the sequential intercept model. We're almost finished with that report. We cannot wait to share it with you. Hopefully there will be little nuggets in there that everybody can take back to their own county. And we can't wait to give it to Denton County so that they can start on their plan of action for improving things there. Rose created a video from that mapping, and I'm sure she would love to show it to you. Yes.
Everybody gets a video but me. I'm gonna have to get with you next time, Rose. We'll do something for grants and stuff.
We're going to our other two pilot counties, Grayson County in June and then Smith County in August. But this is from Denton County, y'all.
As a community diversion coordinator, I work with individuals who have been brought into the criminal justice system who have an identified mental health concern, and I work with getting them into treatment and diverting them out of our jail systems in hopes to reduce recidivism rates and our incarceration population. Some of the diversions that we use here at Denton County, we work with our local mental health authority, and we work with getting them assessed while they're in jail to determine maybe if they need inpatient, we can divert them out. We work with the LMEJ to also provide treatment when they are released, to connect them with resources and support. And we also do work with the jail health, who also provides treatment in the jail.
My name is Chance Oliver, and I preside over County Criminal Court at Law Number 4 in Denton County, Texas. And we're a misdemeanor court. We only handle DWIs, theft cases, assault cases, things like that. but recently we've taken on this new mental health aspect of it with the grant program that I was designated as the criminal court. Generally, my impact that I do is not necessarily in our courtroom, it's outside before the case filing situation or stuff, working with Erica or other people, the probate court or other judges in that.
We all get together and we collaborate about the concerns that are happening in each county, and we share ways on how to overcome those. We share ideas. We also work with JCMH to provide best practices within the county system.
She's doing great, and I've heard great reports from multiple people about just the access, the opportunities, and the results that have been obtained by her just being there and following through and being someone that people can contact.
One thing that I think we excel here is we all identify that there is a problem here. And so one thing that we are hoping to bring from this sim mapping is to bring all the departments together so we can collaborate, we can identify those areas that we need to work on, identify areas that we're doing really well, and then develop action plans on how we can make it more efficient and effective for the individuals that are involved in our system.
My name is Becky Hafiz. I am an assistant district attorney with Denton County. I know the mental health crisis is something that everyone's sort of talking about, judges, the DA's office, defense attorneys. I think we definitely see cases where you think, okay, this event was brought on by some sort of mental health crisis or someone was in a really bad headspace. It could be an assault or a criminal trespass, and sometimes you wish those had been caught early on. Sim mapping, I thought it was like a geographical term until I came and I understood what these intercept models are. And the number one thing I learned was how little I know about all of this, but really sort of learned that every agency and office is sort of dealing with the same issue and how important and beneficial it would be for everyone to collaborate.
I thought there were some good conversations. I thought there were questions asked that needed to be asked, and I think there were good people in there to have responses to that and to start those discussions that need to go further to fix the problems that we definitely have.
There was a lot of brainstorming about how to move forward and what everyone can do to get involved, and so I think it'll go somewhere. I think it'll be great.
Thank you again. That just captures it so much better than we could describe it for you. Okay, we're going to hear from Kama Harris now about progress with our Eliminate the Wait initiative.
Thanks, Christy. Good afternoon or morning, everybody. So we recently went to the Texas Association of Pretrial Services Conference in San Antonio. And Christy, along with Dr. Simpson and Simone Saloom from HHSC, they spoke on a panel about Eliminate the Wait. And at that conference, they debuted the pretrial services specific checklist. So that included ideas such as considering the 1622 report and touching base with the LMHA before offering bond conditions or pretrial release, and considering mental health or IDD specific caseloads for those pretrial officers. But this is just an initial draft of that checklist. And so we're asking anyone who has a special interest in that or expertise to reach out to us, and we can send you a draft copy, and we'd love your feedback on it. And then eventually we'll get it to a place where we can release it publicly. Thank you.
Great, thank you. They tell me I don't need the microphone anymore. So I think we've got everything set up now. Okay, and now we want to hear from Liz Wiggins about our technical assistance.
Hello. So as you all know, we've rolled out our technical assistance services this year. It basically just formalized the services that we were already providing and added a few new services. So we're still providing connections for peer networking and expert consultations. Sorry. And if you're interested or willing to share any specialized knowledge that you have, please let us know so we can add you to our list of people we can connect with. We also are helping do mapping workshops, as Molly talked about, and we're also helping with courts who want to start a mental health court program. We released the 10-step guide at the Texas Association of Specialty Courts Conference in April. Right now, I'm not sure how many people know this, but there are about 14 counties in Texas that have a specialty court program for mental health court that are recognized and known in Texas. Many of you are already involved in those courts, but for those unaware, mental health courts are a type of specialty court treatment program that connects defendants with long-term community-based treatment. Mental health courts come in various shapes and sizes. The courts do use assessments, individualized treatment plans, and judicial monitoring to address both the mental health needs of individuals and public safety concerns. Mental health court programs are often going to be decided as far as what kind of program it is. It's going to be decided by the community needs as well as the available resources. If you're thinking about creating a program, please let us know. We'd like to help. And we're also hoping to release a full toolkit this fall that will help more with creating a program. You can learn more about our technical assistance on our website. And that's it for me.
Great, thank you so much. You can tell that we have been very busy and appreciate growing staff. So next, I think Justice Bland is going to walk us through our committee reports.
Yeah, and just picking up on something that Liz was talking about, one of the things I know that many commissioners are focused on is what do we have on the ground in the 20 most populous counties in terms of mental health courts and resources. And, you know, one of the goals is to target those 20 counties and find out what they have now to the extent that they haven't formally constituted a mental health court, find out what they do have and find out whether we can offer assistance and help in getting something up and running in those counties, because that can be kind of a hub for the additional resources that we want to bring to bear to people who are encountering the justice system. But without having sort of contacts on the ground, that's harder to do. So we're looking at that, and we can use your help to the extent you're willing to help share your knowledge and expertise with other counties that may not be quite so far down the road in terms of addressing these issues in their courts. Okay, so now we're going to go to, and Molly, I know we interrupted your report in connection with the video, and I wondered if you wanted to just talk briefly about the collaboration that we're going to have with the Children's Commission.
Yes, ma'am. Thank you, Justice Bland. I'm very excited about this project. I think once you all hear about it, you're going to be very excited about it as well. But thanks to the inspiration of Justice Huddle, who's Deputy Liaison to the JCMH and also Deputy Chair of the Children's Commission, we are co-hosting a roundtable meeting in June with the Children's Commission to focus on the mental health crisis in children that we've been hearing about since the pandemic, even pre-pandemic. It is cresting now. There are increased numbers of children without placement in foster care and increased commitments to the Texas Juvenile Justice Department due to complex, unmet mental health needs in children. The roundtable will provide a forum for stakeholders from child welfare, from juvenile justice, from mental health, and from court systems to identify some strategies to collaborate and support children's mental health. Is also going to be a jumping off point for new projects for both of our commissions. Space is limited, so it is by invitation only. I do want to thank Justice Huddle for her vision and her leadership on this issue. I also want to thank Justice Bland and Judge Hervey, who have always been encouraging and supportive of our efforts in children's mental health. So look for that. That's coming up too. Thank you so much.
Yeah, and the thing about this is it can help expand our platform, because the Children's Commission, as many of you may be aware, operates and manages a number of courts across the state that are focused specifically on child welfare issues. And so they're encountering everything that anybody in a mental health court is encountering, and especially post-pandemic, we're reading about how difficult it has been in particular for children and in particular for vulnerable children. And so this is a way to cross-pollinate and get ideas, share ideas, exchange ideas, and also deploy resources across a broader spectrum of people who are in need. Okay.
I have a question.
Go ahead.
Molly, is TEA going to be there?
Yes, representatives from TEA have been invited.
Maybe we need to call and make sure that someone is attending.
Yes.
We will be following up. We know that
Yes.
there are a lot of folks who are very interested. We've already developed a waiting list, so we're managing it closely.
Great. Okay. And now we're going to go to committee reports, and Judge Camille DuBose is the chair of our bench book committee, but we're going to let Kama speak on that this morning in Judge DuBose's stead.
Thank you, Justice Bland. So in 2021, we published our third edition of the Mental Health and Intellectual and Developmental Disabilities Law Bench Book, or the Bench Book, as we call it. So far, we've distributed almost 900 copies, hard copies of that book. And we have also Lawbox went in and hyperlinked the book. So now on our website, you can open the book and click on, it'll send you to statutes, it'll send you to case law. And I believe it goes within the book as well, different sections. So that is available on our website and also through the Lawbox app, which is available on smartphones and tablets. It offers other publications like the code books and statutes, as well as our bench books. And I believe TCJLA has books on there as well. Right now, the bench book committee is on hold. We plan to reconvene in 2023, kind of in correspondence with the legislative session. But I now would like to introduce Molly Davis, who's going to sub in for Judge Wheelis for the juvenile bench book.
Thank you, Kama. I don't think Judge Wheelis would mind my telling y'all, but she's on a surprise cruise today. She could not be with us. She would love to be with us. In 2021, we also published the second edition of the juvenile bench book. Since then, more than 600 copies of that new edition have been distributed to stakeholders. We have just a handful left. So if you want one, please see one of us. We'll get one mailed out to you. It is also available for download on our website. You can also get it through the Lawbox app for Apple or Google, the Android phones. So you can always have a copy with you. But back to Kama, who's going to tell us about the summit.
And I was just confirming with Michael, I think we have some bench books here if anyone needs a spare copy. So yes, I'm subbing in for Judge Carr on the summit. The Summit Curriculum Committee, they convened on May 6th, and we have started working on the 5th Annual Judicial Summit on Mental Health. It's going to be held at the Great Wolf Lodge in Grapevine, Texas, which is right near the DFW airport. Easy in, easy out, and registration is open. We already have 50 registrants, so that's exciting. This year, the summit will begin on a Wednesday afternoon, so November 2nd. It'll be a half day on the first day, a full day on Thursday, a half day on Friday. And there will be plenty of breaks between sessions for lots of networking. We will also have a virtual option because our capacity, as Justice Bland said, is limited. It's between 400 and 500, and it always sells out. Topics proposed this year include a mental health court Stump the Experts Q&A and information on AOT programs and the newly published AOT Practitioner's Guide, which we have a couple of the authors in the room. And we're also going to try to get sessions on the practicalities of litigating mental health and IDD cases. And we're going to have 2 tracks, a juvenile and an adult track. So really broadening their scope this year. At the last commission meeting, Rose was able to show us a map of the primary county of work for registrants at last year's summit, and that is up on the board. This year, our goal is to have at least one person from every county in Texas register and attend the summit. And we've launched what's called the Whole Texas Campaign in order to get the word out. So we would love your help in targeting your colleagues in your neighborhood county or your neighboring counties and counties that are underrepresented who may benefit from attending the summit. As part of this campaign, we're going to track registration each week and update the map on our website. And I think Rose, here's our first map. So here's where we are with 50 registrants. And we hope to have this whole state filled with color by the time the summit comes in November. And Rose, so she does such amazing videos, is going to do a promotional video for the summit. So if anyone would like to talk to her, she's doing quick clips today, maybe at lunch or after the meeting, just about how much you love the summit. And if we don't get volunteers, I might approach some of you. Thank you. And now I'm going, I think, back to Molly for the Forms Committee.
We can take the show on the road, Kama.
Yeah, we can.
Judge Shannon was unable to be with us this morning. His schedule is just jam-packed today, but he is chair of the Forms Subcommittee. In 2021, the Forms Subcommittee completed work on standardized forms related to emergency detention, orders of protected custody, ordered mental health proceedings and IDD services, jail and registration forms, incompetency proceedings, and applications for psychoactive medication. Also intellectual and developmental disability proceedings. I am so happy to announce that those forms are on our website, on our forms bank. So they're ready for you to use. Some of our stakeholders have already let us know that there are some tiny errors in there. So there might be a gold star or a Mars bar for you if you find another error. Please let me know and we'll fix those. That committee was also asked to make some recommendations to the Rules Committee on whether any of those forms would be made mandatory. The Forms Committee met about that again this week and had some input from other various stakeholders and decided that they are not making any recommendations on whether any forms should be mandatory. And I believe that that concludes the work of the Forms Committee. So next, we'll let Judge Spisha tell us about the Long-Term Planning Committee.
Thank you, Molly. Yesterday, we spent the whole day working on the Long-Term Planning Committee. We had a really neat discussion. We had a lot of people there, people from all the various areas of interest. And we started by developing a vision statement and looking at our last strategic plan in 2018 and deciding that we're going to have some overarching principles of collaboration, emphasis on peer support, data collection and sharing, increased focus on children's, youth, and families. And we are literally in the process of developing the next plan. We are going, once the plan is developed and we send it out to the entire committee, and make whatever modifications we need to, or we are going to present it to the executive committee for their review. Hopefully they're approving it. I am also the jurist in residence, and since our last commission meeting, we put out a letter announcing the Form Bank and other commission news, and we'll have another one coming out shortly. They're all archived on our JCMH website, so you can go and look there. If there's one you have trouble finding, I have trouble finding all kinds of things. They'll email them. So next I'd like to introduce Dr. Connie Almeida. I don't know where Connie is, but she's here.
I'm here.
Okay, okay.
Thank you, Judge. So just a brief report on the data committee. This is actually one of the newest committees, and I know the most popular for everybody to talk about data. So we've actually had 2 meetings this year. The last meeting was in March, and we've taken a break for a couple months. I believe our next meeting will be in July. Liz keeps me up. And the importance of data is really, first we have to start with what data do we have? Like what's available, either through OCA or what are judges collecting, what's available. So we've been learning. And then I think the next step is what kind of data can we collect, and how do we do that in a user-friendly manner? And how do we use that data? I think that's really important. Sometimes we can make things really complicated and we can't sustain it. So we're really spending some time on that. We have 2 subcommittees that have been formed, one that focuses on the 1622 process. And again, what information is being collected, what types of assessments, how many assessments are done, what percentage of the population does that represent that are booked into our jail? being filed in a timely manner, all those kinds of things are really important. And again, how can the courts, how can the justice systems, the judges use that information? And that's being chaired by Judge Huff from Bear County. And then the second subcommittee focuses on the other big issue, competency restoration. And the competency restoration list that we have in the state of Texas, and working again with the Health and Human Services Commission on that, specifically the Joint Commission on Access to Forensic Services, and looking at that data and looking at who's on that list and what can we do collaboratively to reduce the list in Texas. I think that is it. Any questions? And I do not have a video also. Budget and data, no video.
And Connie, actually at our meeting yesterday, we had a lot of discussion on data collection, use of data in building programs and measuring programs. So we're kind of dovetailing on that.
And that's great. And in terms of the ladder and the wait list, have you talked about trying to get a breakdown of offense to misdemeanor versus felony? I think that'd be very helpful to know too, because we've got total numbers on the wait list that one can find online, at least with respect to the maximum security and not, but then of the not, a further breakdown by at least range of charge might be helpful.
And I just wanted to add that John Petrella is actually chairing that subcommittee and again, looking at that data. Yes, definitely.
And the importance of what you're doing is we need that to move other things, other pieces forward, including legislation, which Justice Boyce is going to talk about.
Thank you, Justice Bland, and good morning to everyone here. I'm going to tick through a number of proposals that are being discussed, but it may be helpful to have just a little bit of an overview of the timeframes that are involved. So this will be coming up the third legislative session in which the commission is making legislative proposals. And we anticipate, I think, presenting in August or September, that may still be a little fluid, to the Texas Judicial Council, a suite of proposals out of the topics that I'm going to go through right now. And I think what you can anticipate is with some further development, we will have a further presentation to this body of what the suite of proposals are going to be. Then those will be presented to the Judicial Council, and the Judicial Council would be the entity that votes to move forward with proposals on behalf of the judiciary as a whole. And time-wise, I think our schedule has fortunately moved a little bit to provide some additional time for development, which is always welcome. By way of review, you may recall that we've broken down the Legislative Research Committee into a civil component that Judge Carr has been heading up, and a criminal component that Professor Shannon has been heading up. And so as I tick through these, I will certainly invite Professor Shannon and perhaps Kema, if you're pinch hitting for Judge Carr, or Molly.
I'm gonna do the civil one.
Okay. To elaborate on anything that you think would be additionally helpful to hear about in these proposals. You also recall that the part of the bigger picture here is because of longer timeframes that we have as a continuing commission, to really look at not just having Band-Aid fixes to particular problems with particular statutes, but instead to have more of a thoughtful approach across multiple sessions to really identify larger themes and larger goals and work with those goals to come up with proposals that help to achieve them. And I think it would be fair to say that in terms of big picture areas of focus, the commission and the Legislative Research Committee has been focused on improving the competency restoration process, clarifying the 1622 identification process, and in a broader picture, coming up with alternatives to arrest for people who are experiencing an acute mental crisis. And so as we go through some of these individual proposals, you're going to see that those are facets of these larger goals and programs. I'm going to go through a number of programs here, or a number of legislative proposals. Some of these are fairly far along. Some of these are more at an initial discussion stage. You shouldn't take away from this that the following 24 items are going to be presented in the fall. I think this is still a area of discussion with a larger pool of ideas and possibilities, then narrowed down to the slate of proposals that we're going to present in the fall. And I will go through these and invite you to follow along on the screen that I will not be able to see because it's behind me. So I'm going to start with the civil subgroup that Judge Carr has been heading up. There are 7 proposals that are under discussion right now. Yes, okay, good. We're lined up with the civil part here. And again, you're going to hear some of these recurring themes. One proposal, an initial proposal, is to amend the Health and Safety Code to allow an employee of a local mental health authority to submit an electronic application for an emergency detention for an individual who's already in the medical or mental health facility. This would be an adjustment from the current circumstance where only physicians are able to do this at present. And this would be a goal towards providing additional flexibility. The second proposal would be to amend the Health and Safety Code to allow law enforcement to seize a firearm found in the possession of a person who is the subject of a warrant for an emergency detention. And this is a technical adjustment to take an existing procedure and apply it a little more broadly. Currently, law enforcement is able to seize a firearm from a person who is the subject of an apprehension by peace officer without a warrant for emergency detention. So the proposal that's being discussed would allow law enforcement the same authority to make the situation safe, regardless of whether the emergency detention was by warrant or was by law enforcement. And there would be an accompanying amendment to the Code of Criminal Procedure that would allow this to be implemented.
Bill, can I interrupt you for a minute?
Certainly.
Is there any consideration to go beyond firearms?
I don't know that the subcommittee has discussed that, but that's certainly a possible topic. A third proposal would be to amend the Health and Safety Code to allow blood draws from patients who are in custody or already under a court order to receive inpatient mental health services. This is a practice that would allow evaluations for the proper administration of psychoactive medications. The fourth proposal is, would be an amendment to the Health and Safety Code to address the roles of law enforcement when a person has been transported by law enforcement to an emergency medical department. And really 4 and 5 kind of go hand in hand here. You may recall this has been a discussion that has been going on for a period of time. It was a discussion prior to the last legislative session and continues to address the roles of police departments and emergency medical health services when somebody is brought in to the emergency room or a similar situation in crisis. And it specifically addresses a circumstance and a concern that has been expressed about law enforcement officers, particularly perhaps in smaller areas or geographically dispersed areas, to have clarity about whether they are required to stay in the emergency medical facility, or what are the circumstances are for the responsibility for the person who has been brought in, and relatedly under proposal 5, whether or not there's a requirement to get medical clearance before a mental health facility will treat a patient. And again, this is aimed at addressing circumstances particularly that have been identified in rural areas or geographically spaced out areas. One of the overarching pictures here that we've talked about from time to time is that Texas and its 254 counties is not a one-size-fits-all kind of situation. There are circumstances in urban areas, there are circumstances in mid-sized areas, and there are circumstances in rural areas. And I think these proposals reflect that reality. 2 more civil proposals that I'll discuss are really more in the earlier developmental stage to discuss and require crisis receiving centers and to expand assisted outpatient treatment courts. The proposal would be to expand the numbers of these facilities, perhaps by a grant program for assisted outpatient treatment courts that other states have done, or possibly by characterizing AOT courts as specialty courts in the government code. Proposal to require crisis receiving centers would reduce burden on local emergency departments to provide care for people who are experiencing an acute mental health crisis or symptoms. And there is federal legislation that potentially could guide this type of proposal at the state level, as well as different models from other states that are being examined. So that's a summary of what's being discussed on the civil side. I'm going to turn to the criminal subgroup proposals. And again, I'll invite Professor Shannon to elaborate.
Good voice, and I'm not elaborating on that yet. Just want to make I'm not on the civil committee, but wanted to make a comment about, I guess, number 6. I think it's a wonderful concept to try to have more AOT courts around the state to be able to then deploy some of these diversion programs like we were just seeing in Denton County. But correspondingly, and David's here, Bess here, capacity for the local mental health authorities to provide the services for those expanded outpatient programs that AOT court would be doing, that's critical too. So I know we don't have appropriations authority, but we need to make sure and note that the service need is there as well.
I see vigorous head nodding. Did you want to add anything, Beth?
No, it's just, I mean, you know, you hear more and more that local authorities are going on wait lists for people, and so they don't have services for people. And so to push AOT programs when the local authorities don't have the services to provide to people does not make a lot of sense. So, and then what we end up doing is you end up moving people that would like to get the services, who would voluntarily get the services and would stay out of systems, and get them pushed out because you're now forcing other people into the program. So I think, you know, really, as we look at these kind of forced programs, we really need to ensure that we're increasing the services that are out there. Because right now, we don't have those services. I mean, you know, Tropical Texas just put out a flyer saying, we've got a wait list, basically don't come see us unless it's a crisis.
Not only services, but also facilities. Right. And treatment providers, especially when you're trying to, when you're going to start segregating or identifying intellectual development disability, intellectual development disability. Those folks are not being identified readily or being mixed up with mental health. And of course, those are different, but we need more facilities, we need more appropriation. Legislator needs to open up their heart.
So what I'm hearing is maybe we should focus more on the crisis receiving center aspect of this proposal and how we can support HHS or whoever and ensuring that there's increases in space for outpatient treatment. I'm wondering whether in terms of creating AOT courts, whether they can't come in within under the umbrella of a mental health court, right? And some people there's gonna be different needs depending on who presents, and assisted outpatient treatment could be part of that. Is that, and I'm deferring to everyone out here to figure out where our focus should be.
Justice Bland, I think we can recommend both. They're really different aspects. So appropriate crisis response with the receiving center. Beth can speak more. We're using ARPA funds to develop one in Lubbock. I know others are far ahead of us in that regard. So that's at the front end on the civil side. But the AOT court trying to keep that we've got the world leader here on trying to keep people, out of inpatient and hospitals. And it's a great concept, but it's
Longer
a way.
term.
And it's not so much the mental health court, which is once you're into the criminal side, we're trying to keep it or divert out of the criminal into the AOT civil side. But my only point was, let's make sure that as we propose these, we recognize we ought to have mental health services for these folks too.
Coach Casey, did you
got to slip in that world leader, right?
But thank you. So the reason the recommendation is that important is because the world of funding at the minute revolves around specialty courts at the minute. And when you further define the AOT court as a specialty court, it opens for us the ability to ask for those grants, seek that funding that are available to all specialty courts, when in effect, the AOT court has been institutionalized in statute for decades and probably the original specialty court. More importantly, to echo Beth's concern, pretty much everybody on AOT is a service receiver from the LMHA. That you don't get new people into the LMHA because of AOT. They're all the same people already there. They just happen to be the people failing in services that are already there. So to echo Beth's concern, I agree, putting that through so that we can then receive or ask for more monies during the legislative process of the specialty court helps us bring funds to the LMHA so they can expand even more service.
So in sort of hooking the legislation in, that's what I'm trying to figure out. Can these courts be included under the umbrella of a designated mental health court where we just add a descriptor? Yes. Because we already have that. So convincing the legislature that this subset of courts, and we can even say civil and criminal.
That's why I think it's a that's why I think it's a wonderful thing.
They have to voluntarily agree to with counsel, right? Which is a little bit different. Currently, the way the mental health courts are written. Or on the criminal side. On the criminal side, yes.
Right, on the criminal side.
Yes. That's the mental health court. That's currently.
To expand the legislation so that AOT can be at the table when those discussions happen. That is the statutory probate courts and the LMHA. Then we can engage in those conversations and say, we need an additional amount of resources for that. But again, AOT is important in the context of the criminal courts because it keeps, in many cases, them from getting to the criminal courts. And AOT is important in terms of the LMHA because study after study after study will tell you that the individuals who are not accessing AOT are the same ones going into the LMHA and the EDs and the jails over and over and over again. So it's a tool.
I'm always concerned, right? Because they can't get services otherwise. It's got to be big package, not just the courts. We got to have something to give them.
Absolutely. It has to be
It's like, oh, I recognize you have a problem, but yeah, go home. I mean, so it has to be a total package.
Absolutely.
Well, I think that, and the piece, and that's a great comment though, too, the piece of expanding the list of what's identified and what is it, chapter
Yes.
45 or something, of what are specialty courts, and this being one, so that the grant pools are available.
Well, and if we've already got a statutory framework out there, pulling that in so that it's in a place where it's comprehensively there. And also on the radar for funding. That's what I'm, okay, we can work on that.
So I just want to add one thing. Oh, no, go right ahead.
So when legislation's proposed and in a big package, not, do you, excuse me if this is stupid, but do you list, okay, we've got the courts, we've got the LMHA or R, whatever, and then do you list like, we need more money for drugs, we need more money for doctors, we need more money for, do you list all that out so they know it's not just here, we need more money? I mean, so they really see where the deficiencies are and where more money could actually go to assist people.
Facilities, step down facilities.
Yeah.
Traditionally, and as you know, as you're aware, so, you know, at every legislative process, we have bills that are submitted, which try to gouge out a little piece. And then you have omnibus bills, larger bills that try to tackle the entire program. I think that this, at least with regards to what we're doing, is a small piece of the puzzle, admittedly. But that's exactly the phrase. It's a small piece of the big puzzle that we all should be pushing at some point.
So it doesn't do the funding. So you get the courts, but you don't have the funding and you don't have the services. So I think that's, to answer your question, it is that small piece. It doesn't talk about the funding.
Can I just say on that? I mean, these are awesome things to do, but I guess I kind of feel like that is sort of the thing someone needs to figure out how to lean more into, because AO without the T isn't worth anything.
Right.
And so, I mean, what's the wait list now, Beth? Like 23?
2,300, almost
Yeah.
24.
What was it like, when we first formed the Judicial Commission, like
600.
600? So we presided over, I mean, it's not our fault, but I mean, like, I'm just saying, like, while we've been looking at these sorts of things, it's 4 times as bad. And I think these are nice things, but I do think there's a bigger thing that I'm not sure is in the purview of just us, but it is something, I guess, I just think we need to acknowledge that we can do what we can do with this particular list, but unless we have allies really pushing the T part, we can only do so much. And I guess I don't know what the right way to do that, Justice Boyce. I think like our purview is not really where we can come in and say, here's what the treatment system needs to have happen. But I do think there's implicit in all of these things is if the treatment system does not dramatically expand X, Y, Z, we can only get so much done from here. I don't know, do we have thoughts about how that frames it?
May I just add that, and I'm sorry that I'm not trying to monopolize, but I agree. The wait list is what we all refer to is the criminal wait list, which is a perfect example of the competing interests in Texas, all fighting for the same issue. We don't have enough money for treatment, period. That waiting list really isn't affected by AOT. AOT is a different issue. It's people waiting to come into commitment or who are in a revolving door being taken in on ED, released from a hospital, taken in on ED, which is equally as important to Beth as the people waiting for voluntary services, which is equally as important. I think it's important that as a commission, we each bring a perspective to try to bring as much resource funding, legislative change to each of our pieces of the puzzle without necessarily arguing that our piece is more important than the rest. But that criminal wait list is huge. How can I sit here and go, no, you need to fund AOT? But equally, AOT is going to say, well, wait a moment, we're keeping people from killing themselves. So I think we can do both.
Tie into the stealing your thunder a little bit. One of the proposals that Justice Boyce will talk about, we're looking at in the criminal committee, is for folks who are only facing nonviolent charges, your Class Bs and some of the Class As. Can we divert them to AOT instead. And that's not going to chip away a lot at the wait list, but at least the last data I saw, it was about 200 people on the wait list have misdemeanor charges only. So it's going to chip away at some, but we have to have the service array and capacity there too. And within the criminal side, 46B, the legislature's done a great job of teeing up a program where, you know, you start for a lot of the offenses, you start with outpatient first, and then you've got options, right? A jail-based competency restoration and then inpatient. Problem is we don't have a lot of service capacity in the outpatient and the jail-based across the state. And we're a big state, lots of folks. So I know you hear the refrain, oh, you can't just fix things by throwing money at it, but you can do more.
I think, you know, one of the bigger issues right now too is staffing anywhere, right? Like you're saying, the providers, the provider base is gone. I mean, the state hospitals have capacity for for so many beds. Right now, they're not using about 500 of their beds because they don't have staff. And so those beds are sitting empty and need to be used. And that's also true for the local authorities. They can't staff up. You know, that's not, right? They can't staff up right now. And people are going to other places that are paying more. You can go to Amazon and get paid a lot more and deal with a lot less stress than working in as a provider. And so, I mean, that is so alone, in order to even start to increase treatment, we have to get staffing back to where it used to be. And of course, that's also funding and money. But I mean, I really think those are things that as a group, we should be pushing for, right? That I really think we need to champion.
And can I ask Dr. Keller, is Meadows going to put forward a request globally for more treatment?
Well, I mean, I think it comes back to what you're saying earlier. I mean, global request for more treatment's not going to go anywhere. We've got to figure out some really specific things. Like Judge Kazin was saying, I think it needs to be something that is, you know, addresses all our lanes. And I think, you know, and that consensus building is hard. I mean, I think, you know, obviously we're not going to get, but I think just what Beth was saying, like, I mean, you know, legislation that would address whatever, I mean, we talked with Tim, who's now on our team, about maybe get some ideas on the state hospital side. I mean, what are the things we need to do so we could actually hire? Because I mean, you know, Walmart's figured out how to hire some of those people. I mean, like, you know, we should be able to figure out how to hire back some of those folks. And my guess is there's some, you know, restrictions in the current funding streams that make it really hard to do that. So I mean, maybe something just looked at LMHA and state hospital workforce, so we can at least use the services we have. You know, I think that's the kind of thing where it's going to take, I think, multiple stakeholders. It's going to take all of us feeling like this really will help with the things we've identified. And then I think, you know, we would be happy to support and get behind that. But I think there's some consensus building. I'm not sure where the right forum. I mean, maybe we all facilitate. I don't know.
And one avenue, like from a couple of sessions ago, were the matching grant programs. That's how some of the jail-based competency restoration programs were established, as well as other programs and others. And I think this was in your remarks. Some other states have done grant programs for expanded AOT courts. And so that might be a way to get at least an incremental approach to.
It would seem that it would be important to enter into a discussion with HHSC. They've got a huge budget, but oftentimes there's not a discussion about, can we build into their budget X amount of dollars to support AOT courts? I mean, that kind of specific thing. If you can get their buy-in early and get it in their LAR, you know, put it in their budget package. I mean, Jenny, I mean, is that?
Jenny.
Yes.
Exactly. I was talking, then I was going to turn to Jenny and say, and Jenny.
No, I think that's really important, is, you know, that piece of working together to figure out. I think, you know, a group can really focus on that, is what truly we, again, look at that data, look at how things are funded and put together. I mean, that's a smart place to start. And doing that. So I think
Our role that we can specifically state that we are suggesting this definitional change for AOT, but a caveat is that we recognize there needs to be more treatment, and we could point to certain efforts of other organizations, is what Justice Bland suggested in the last session. You know, we had that services report that
was supposed to expand on what we were recommending to point to other organizations.
Then, as far as the staffing piece, growing our own and being able to put something in plan as far as the student loans, they go to course, they get an education, they work in these facilities. And what was that, the public service where if you work in this certain area, you get your student loan chipped away at? And something like that, expanding to medical, mental health providers and service providers.
It doesn't help you hire because basically it requires 10 years of service. So people may think about that, but it only impacts a very small group of people because most people move into these kind of positions and stay for a reasonably short period of time and then move on to something else. So really we need new positions, new FTEs, but FTEs that are funded at a level that we can hire people.
And if we're looking at legislation, let's go wild. Let's really think, and see if we could reduce that number of years.
Sometimes on the budget side, you have to be strategic. I mean, going wild on the budget side, budget folks don't like that at all. I've been there. I've been in that room with people, what we've got is really good proposals, but they are going to have a cost. And HHSC is probably going to have to put together an estimate for what that's going to cost. But if we talk to y'all beforehand, we can work together on it.
And just to acknowledge, we do have staff sitting on those committees as well. And so I think, there's input going in right now too, but maybe just further drilling down into what that looks like for each proposal would be good. And really lots of commissioners and collaborative council members who could contribute.
And this is a great example of not doing Band-Aid legislative changes, but really looking at proposals and what does it take to actually have them be effective and implemented, and not just words in the statutes. And I'm gonna, I think Professor Shannon provided a great segue to kind of go to the criminal side of the proposals. And again, these are not hermetically sealed, is the point you made well, that part of the overall plan is to try to not have treatment mechanisms for people who are in the criminal justice system as the last resort, because you divert before they get to that stage, then that is part of the overall goal. So I'm going to tick through the criminal side proposals and some of the proposals that are still in progress. And I'll certainly invite Professor Shannon or anyone else who wants to elaborate on the proposals to do so. The criminal subgroup has really been focused significantly on 7 topics that have been the source of ongoing discussion. The first is to propose legislation that would amend 46B to address alternatives to the use of competency restoration services or competency proceedings in certain misdemeanor cases. Again, to your point, Professor Shannon, one way to chip away at a wait list is to not add to it. And I think those proposals go to that. A second proposal would be to address the circumstances of somebody who is identified while in the criminal justice system, restored, and adjudicative proceedings resume, and they decompensate while that process is going on. And there's a recognized gap in the one of the most difficult questions of governance, and then what happens. And I think trying to address that gap in procedure or services is part of that proposal. A third proposal would be to amend the Code of Criminal Procedure, Article 46B, 009, to allow good time credit for defendants released to outpatient competency restoration programs. This was proposed previously. It got through the House. It did ultimately made it through the House and the Senate, but did not clear it as part of the conference committee report at the end of the process, which is part of the legislative process. And so that would be something that we would revisit. A fourth proposal would be to clarify or expand Article 1623 of the Code of Criminal Procedure, mandating that law enforcement shall make a good faith effort to divert a person suffering from a mental health crisis or the effects of substance abuse to a proper treatment center in the agency's jurisdiction. And there's been some uncertainty about what does it mean to refer to a proper treatment center in the agency's jurisdiction, and how does that interplay with a good faith effort. And the Magistration Subcommittee is looking at amending or expanding this phrase to make the diversion broader and easier for officers. This is still under discussion. A fifth proposal would be to amend Code of Criminal Procedure Article 1622 to include Class C misdemeanors. And you may recall from prior discussions that Class Cs originally were eligible for a 1622 interview and a report under the Sandra Bland Act, but amendments and superseding statutes resulted in Class Cs subsequently being excluded from 1622. And so the Magistration Subcommittee is looking at the possibility of bringing Class Cs back into this procedure, but that is still being discussed. Currently drafted language would make ordering a 1622 evaluation for someone charged with a Class C misdemeanor discretionary, but this is still under discussion. A sixth proposal would be to address the statutory authority for justices of the peace and municipal court judges to dismiss Class C misdemeanors when the defendant lacks capacity. And this would be a proposed addition to Article 45.0214 to the Code of Criminal Procedure to allow a municipal court judge or justice on a motion by the state, the defendant, or a person standing in parental relation or on the court's own motion to determine if probable cause exists to believe that the defendant lacks capacity to understand the proceedings. This was a prior area of legislative proposal passed the House, did not get taken up by the Senate. And again, as in the prior example that we talked about, it was subsequently brought up, got through the House and the Senate process, but fell away with the conference committee report and Senate Bill 49. So again, revisiting that. The seventh proposal addresses cleanups and tensions that exist between the bond bill in the second legislative session in 2021. That created a conflict between offenses in which someone is allowed to be released on a personal bond under 17.03 versus on a mental health bond under 17.032. So there needs to be some repair there or coordination to sync these. Proposals that are still in process, but I'll flag them for your consideration now. One is amending Chapter 26 of the Code of Criminal Procedure to give authority for all magistrate judges to appoint counsel in magistration. This is under discussion. There's not a specific legislative proposal yet. Another is a proposal to require municipal jails and other facilities where an accused is detained that they be subject to current jail standards and regulations. This is another area of a gap because the municipal jails are exempt from jail standards. And again, this proposal is being considered. There's not specific legislation language that's been drafted up yet, but it's the subject of research by the commission staff looking on the legislative history of jail standards and the interaction of those standards with municipal jails. Another proposal would be to create the statutory authority to delay the arrest of a mental health patient detained under an emergency detention or order of protective custody who engages in conduct that may subject the patient to arrest for an assault or another low-level offense until the patient's condition has been stabilized. This was proposed previously, but there was not a specific proposal on how to address this issue. It was not included in the legislation that was proposed in the prior session. But potential statutory language that would be an amendment to Chapter 15 of the Code of Criminal Procedure is being considered. Second to last on the list here, we have a proposal to clarify or expand Health and Safety Code 614.017 to promote further information sharing and diversion of mental health offenders pretrial. And the final topic under more general consideration would be an amendment of Section 574.037 addressing court-ordered outpatient services. This is under the Health and Safety Code regarding potentially modifying access to out-of-county outpatient services by court order. And I think that's still under discussion that Lee Johnson and Beth are discussing that. So that's an overview, but at this juncture, I'll ask Professor Shannon or anyone else who has comments or questions to chime in.
We open it up to questions. Some states, New York notably, on the first proposal, Justice Bland mentioned, hey, if somebody is accused only of a misdemeanor, if they're found incompetent trial, they are diverted to a variation of an outpatient commitment proceeding. Other states have bits and pieces of that concept. So that's one we're looking at. On the one about some gaps on what happens after somebody's been restored and comes back and deteriorates. Unfortunately, we're seeing a lot of those cases now because as we know, a lot of criminal jury trials did not happen for a long time due to COVID and deterioration. And so lawyers, I've gotten calls, seem like every other week from the prosecutor's office, a defense lawyer asking, well, you know, what now? And we just need to flesh out more in the statute. So we're trying to do that.
Professor Shannon, can I ask, it's a discussion I think we've had over the years, but we've got that population in the jail that's waiting to get restored, or forgive me, at the facilities, those who are in jail waiting to go to the facilities. But we have those that return from the facilities restored. And there's not just because of COVID, but they come back restored, they get into the jail, they get to the jail. Some of them are not on bond. And what happens just as a practical matter is that they drop in the judge's docket. I've got, for example, if I was a district court judge, I've got a murder, I've got an ag assault, I've got something that's older, but I've got somebody restored on a 3rd-degree felony or 2nd-degree felony. What's going to happen to that case is it's going to drop to the bottom of my priorities.
And it should.
And it should, right.
Change that statute, say that goes to the top.
Correct.
But it's not, you're right, it's not happening.
Yeah, it's not happening. And that statute isn't specific enough to say, if they're restored, they shall be tried within 60, 30, whatever days. But there's another component to it. The state could step up think about it. What's the visiting judge on a criminal case? $600 a day, $500 a day? You know, for a 3 or 4 or 5 day trial in some cases. The state should step up with a visiting judge fund so that if I'm the district court judge and just got a 3rd degree restored person come back, but I've got 15 other cases in front of them, I've got a fund that I can tap. Visiting judge is going to try it. It's got priority. Off it goes. You know, that's as a practical matter, and give the DAs some notice ahead of time that they're about to get discharged.
I know I'm not part of the circle, but I'm a prosecutor with the DA's office and I deal with this daily. I just finished a contested restoration trial on a murder case, which is a whole nother story 3 days ago. But Judge Kazin is right about a 30-day component. But what I'm finding is they want to now have a sanity evaluation, which takes time. So we negotiate with SASH. I am on the phone with SASH on Fridays, staffing cases that are restored. And I notified the defense counsel and we try to come up with plans. What we're finding is those that are in need of a sanity evaluation, that's where the gap comes. So we're having months waiting for the sanity evaluation. What Sash and I would like to do is work out a way where they could stay at the hospital and have a sanity evaluation and not have to go to the jail and then wait for that sanity evaluation, possibly to compensate and then end up back there. If there was a mechanism where they could stay at Sash and wait and get their sanity evaluation done while they have been found restored, that would be very, very helpful in keeping people from decompensating quickly. So that's what we keep running into.
Just playing devil's advocate though, then that's another bed that's continue to be occupied while someone else is waiting.
And I guess
You get that too.
the point would be is we probably need to discuss as a recommendation, a codification of track that a person takes once they're discharged from a hospital. More often than not, these people don't get to trial right away for whatever reason. And more often than not, they decompensate. And then more often than not, they're right back on the waiting period to go back to SASH or Vernon or whatever. As an aside, I think it would also be helpful for the judges in each jurisdiction to be able to tap a visiting judge fund for those priority cases so that they can not say, well, it's a 3rd degree, I got 2 murders, it's older than this, that's what's going to go first. Kind of thing.
Yeah, but it sounds like that's not necessary. I mean, that might be a little bit of the issue, and I don't think that that's a bad idea, but that what you just brought up is a completely different issue in terms of what do you do with people who aren't going to get tried right away, and do you continue to use up a state hospital bed for that person when you've got a wait list of 2,300? That person could come in and could be restored in 30 days, which might be a lot quicker than that sanity eval would get done. Right. So, and that goes back to staffing, because if you had more staff at the hospital, you might be able to actually have that sanity eval done.
We could fast track a sanity evaluation in 2 weeks. And
if they had staff.
And well, I mean, Sash is willing to work with me. I mean, this is what we're facing. And the people I'm thinking of, the people that I see daily are likely in GRI and are likely coming back to you anyway. So
I didn't mean to cause a debate. I was just trying to say it might be a good thing to talk about, because we are running into individuals who are coming back, not getting tried, becoming incompetent again, and then adding to the list. So I just think it's something we need to focus on. And again, just in terms of perhaps whatever it turns out to be, some set track and statute that says this is how we handle people coming back who are restored. And additionally, now this is a price tag. You know, it isn't all that much money for a visiting judge fund so that the judges can tap into giving it the priority it deserves.
So I have 2 comments, and I want to say a lot of these proposals are really great. So thank you so much for everybody on the committee working on that. First thing that I want to talk about is the wait list that we talked about. And so I'm backing up just a second. And we talked about jail-based, we talked about the wait list, we talked about a lot of things there, diversion. And I think that kind of what we've done, I know I looked at Mike Lee as we talked about the wait list, because Harris County, the largest jurisdiction, the wait list is 2,300. We have a little over 200. We actually have about 220 on the wait list. 20 of those are in jail-based. So I want to point out to everybody that typically when we have them in jail-based, they're still on the wait list. So somebody needs to look at the numbers and pull out the jail-based because that's what it really is, just to say. But when they're in jail-based, they are still on that wait list. So somebody needs to look at that. So I just wanted to point that out. I also wanted to say, I think great ideas on the misdemeanor because that's how we've cut our wait list. We are not the leaders in the wait list. You would think Harris County the biggest, that we would be the leaders. We are not. And it's because the misdemeanors, we've really kind of cut those out of competency restoration. How have we done it? Diversion, pre-charge diversion, which Mike Lee, big proponent on. Let's not even charge them. And so we have done that in collaboration between the DA's office and law enforcement, along with our local mental health authority. The other thing is when we are, they do get charged with misdemeanors. And sometimes they might be incompetent. So we have also got a post-charge diversion. It's basically the same kind of thing as a pre-charge, but you didn't catch them on the front end. Now we kind of see that. So post-charge, that same kind of thing, getting them over to the diversion center and some help. So dismissing the case in that regard, same kind of thing. So that has washed out a lot of those. And so I think that's where we can save a lot of money. Our time frame is so short on those misdemeanors. I mean, what are we really doing anyway? So I think it's a great proposal in that regard. But I think multiple things need to be looked at. And I think another thing that really needs to be looked at is jail-based competency restoration. If there are not enough state hospital beds, our local jails are still housing those individuals anyway. I'm a big proponent of jail-based competency restoration. It's not the loveliest facility for them to be in, but we have a 93% restoration rate on that jail-based competency restoration. We're able to get those people on down the road within about 60 days to proceed on with the criminal case. And a lot of it is, you know, I'm no expert, but getting them on the right meds and really just kind of getting them in that regard. And so if we're able to get them restored in that kind of time frame in the jail base, it's saving a lot of transport time back and forth. The jail is housing them anyway. Let's go ahead and get them on down the road and we can proceed on the criminal case. Because once they're restored, remember, we're not necessarily waiting for a trial. We may get a plea bargain on that case. So you have to keep that in mind. If you get them restored in 60 days, 93% rate of restoration, you're able to get a plea bargain, move it on down the road kind of thing. So just something to really kind of think about as we're thinking about these numbers, because I know sometimes it's important to think about the practical aspect of things. And then expediting the trial if they're restored. And I'm all in favor of that. The problem is you can get in a 2-week trial and sometimes they may decompensate during the trial and then you're kind of right back at the same thing. The insanity defense issue, sometimes defense may not, as you well know, raise that until you are a little bit more down the road. And then that may be raised kind of thing. And then that delays things. So there are a lot of issues there trying to expedite the trial if restored. I'm all in favor of expediting trials because sometimes that can result in the plea bargain and you get it resolved. But I see great results in the statutory language, which has expedited like our child sexual abuse cases. I would say by and large, that division in our office they try probably about, I know in March, over 40% of the trials that went in our jurisdiction were all child sexual abuse trials. That's a lot of trials. And so I know that the statutory language does expedite those. And so that is a good suggestion by you, Judge, in that regard, because it does expedite it. I'm not sure it's the ultimate solution, but I think, you know, every little bit helps. But anyway, I hope that whole practical thing really kind of gives everybody something a little more concrete, because as we're talking about statutory amendments and proposals and things like that, it's good to really kind of understand the dynamics of how the practical aspect works. But anyway, thank you so much for your work. I mean, you're obviously super expert on all that stuff. Thank you so much. Appreciate it as always. As always.
That's a technical legal term, super expert.
I'm sorry, go ahead. I just wanted to add maybe 2 comments. I could add a couple more, but the continuity of the formulary, between the state hospital and your jails, that's also an important piece. And again, there's a lot of variability. because you can either be a private provider or the local mental health authority. But that is something that we've done at the local level. And again, to help maintain that restoration, because really, if you've restored somebody and then they come back to your jail and you don't have the right meds and you have a limited formulary, I mean, likely to decompensate. So I think I don't know if that's something statutory, but it's a good practice, maybe something that we try to enforce.
I think that we did endorse and the legislature passed in the last session a requirement that the Jail Standards Commission have as part of their rules for jails to follow that meds that are prescribed by the docs have to be made available.
Right.
So whether those rules have been adopted yet or applied is another question. We tried to push that.
You got a lot of county jails that are like, I'm not gonna pay that kind of money when I've got this instead.
Right,
You know,
right. So maybe we can, and I think the other thing around the jail-based competency restoration, there's, yes, I agree, and we're looking at developing something, but we're not Harris County, we're not one of the big counties, but we're pretty sort of a medium-sized county, Fort Bend County. And so we actually have space, and which is pretty amazing, but maybe don't have the number. So one of the things that we've actually talked about is maybe regional jail-based competency restoration programs. Because again, some of the smaller counties might not have the capacity, the expertise to develop these programs. But, and again, I don't know if that's a legislative recommendation, but sometimes we're so tied to county-specific programs that it leaves out so many other counties that we don't have the workforce, we don't have the expertise, and we don't have the resources. So,
and Connie, we did look at Fort Bend's numbers because I know obviously much less kind of thing. And even thought about, because I know you guys have been talking about jail-based, but really small. I mean, we have 1 unit 20, we should have more than that if we just had the money for staffing, because they're already anyway, Mike, over there. So, but yeah, so I see what you're saying, because we did look at your numbers and because we heard that you guys were kind of thinking about that. And we're like, gosh, I'm not sure you could even make, one of our pods. Yeah.
We'd love to send some of our people over to Lubbock.
Yeah, that's a conversation with Mike.
Just real quick, this is not directly on this issue, but it's just, I'm old and jaded and few things upset me anymore. But the thing that is just driving me and judges in El Paso County nuts, and mind you, I'm proud to say that OCA tells us we're one of the counties that's leading the forefront and doing a really good job of implementing SB 6. But my concern, and it just because it's outrageous how the legislature took away from judges the discretion, the very fundamental thing that we do, trial judges on a day-to-day. My concern is that what SB 6 is doing is jail population is going to increase. And what impact that's going to have on our folks that we're working on this commission, that's my concern. And so it's really more of a caution of, you need to really keep an eye on that, because those numbers are already going up. And they're going to continue to go up as more and more counties in the state of Texas implement SB 6 effectively and efficiently. Those numbers are going to go up. Discretion's been taken up. It's taken away. It's now mandatory. We do not have the ability to release people on PR bond the way we used to. And so that's going to continue. And I think the interplay that's going to have with people who have mental health issues and mental health needs, specifically what jails are able to provide. I mean, we already have a hard enough time, I think, providing the issues that Casey was talking about, of being able to say, you need to do this, and like, nope, we're going this much cheaper route. And I'll take something over nothing, but I think it's going to become more of a challenge. And I think we just need to be very vigilant to keep an eye on what that interplay with the rising jail population is going to have on folks with mental health needs in the jails.
That's why I want to push the version of arrest for people who are on APALs or emergency detentions that are at facilities. And while they're there, because they are already determined to be dangerous to themselves or others, act out and then get a charge, and then they yank them from that place and send them to jail. right? And so we have a provision that we tried to do last session that we're looking at again this session, that is one of those places that we can really look at preventing people from going into jail and remaining at a place where they can get the services that they need, which is where they were brought to initially to begin with. And so really pushing for that.
What about step down facilities? Is something in between the taking off the beds and going back to jail? Something in between that they can be housed in order to be able to continue with treatment.
Well, here they were already in treatment. That it wasn't, they had a place, they had a bed, they were in treatment. It's just that they ended up potentially with a nurse at the facility. They may have, reached out and, got angry and slapped them or whatever else. And then they put a charge on them and sent them to jail when they already had a bed and a place to stay for treatment. So yes, and I agree, we do need step downs also, but this is not even a step down situation. This is where they are in treatment.
It's reverse diversion.
Yeah, exactly.
So I'll make this observation, which is in the last session, there were 10 commission proposals that actually were enacted, which is fairly remarkable that passed to begin with, but 10 is an achievement. And it's achievement because of discussions like this, and particularly credit to Professor Shannon, to Beth, to Judge Carr, to everybody who's participating in the legislative committee's discussions of hashing out issues, working them out and coming up with proposals that actually address issues and can get passed. And so that's a credit to the quality of the discussion that is undertaken in the committee and the shepherding of that process that Professor Shannon and Judge Carr do. I think there's a commentary.
Yeah, I just want to add on to what the judge says. Michael Zito, I'm from Bear County and I oversee our jail population and pretrial services from that end of it. And just Senate Bill 6, since January 1st, we have 249 more people that are in there that we can't get out because of Senate Bill 6. And we're in May. And our projection is that we'll probably have 800 more. And we're going to be looking at maybe some jail expansion or building more jail beds because of Senate Bill 6. So I really think it is something that you have to look at. And out of that 249 that are waiting, probably about 70% of them are behavioral based issues. And they're in there for nonviolent charges now currently. And, I really think it is something that has to be on the radar because it's set us back because we've been working on bail reform and bail issues for a number of years. But SB 6 is putting us on the back burner, and it's going to rethink our philosophy. Is it more that we do just need to lock more people up and have a larger facility? And it's really setting a whole system back.
We need to build more mental health facilities in jails.
Yeah, thank you for that. I'd note, too, we are looking at trying to see if we could have a carve out to the bail bill from the second special session to exclude 17032 to be able to restore that tool that was there. It's politically sensitive, as you might imagine, but through some of our contacts, both Megan at OCA, talking to some staff from Senator Huffman's office, there's likely going to be a cleanup bill. And so if we can position to include this recommendation, but hearing stories like this of the direct impact on some of these low-level offenses is very helpful to be able to persuade, I think, that, wait a minute, this had been passed by an earlier legislature for a reason to be able to have finding out with a treatment condition. Can we go back to the pre-status quo on that? And you had a data comment too.
I'll follow up with you, Mike, but are you all doing a breakdown of the people with IDD of that? Did you say 249? So
Right. No, we haven't done a breakdown as far as IDD, but behavioral healthy.
Christy, did you have a
Yes,
question?
I would just like to look at proposal 11 that Justice Boyce brought up, that was to clarify the information sharing carve out to HIPAA. I am working on a subcommittee for that one. It still doesn't have any language. So if anyone is interested in that issue, some questions that I have that predate my work are in the list of professionals that are in that carve out. Prosecutors are not included. And I wondered if there was a reason that we knew why prosecutors weren't included in that.
Just be for continued treatment, and prosecutors aren't providing continued treatment.
Do they not end up being in part of the conversation?
But so the whole point of the information sharing was only for when people needed to enable continued treatment, right? It was all based around treatment, which is what HIPAA allows for. The carve out in HIPAA just talks about when you're going to provide continued treatment. And so that was why the information sharing between hospitals and jails, or between, outpatient and hospitals, was allowed because it was for the continued treatment. Prosecutors aren't providing continued treatment. They're not in part of that treatment program.
What with all the prosecutorial diversions available? Could we not consider that part of the continuity of care? Because I feel like good prosecutors are already in these conversations sometimes.
Well, so if the client gives permission, then it doesn't matter anyway, right? So if they want to go to diversion, they're gonna give permission, so.
Some part of the answer is just that natural friction, which is healthy, between people who are defense oriented and people who are prosecutor oriented. So there's always going to be that natural, and it's healthy. But there's that natural belief, I'm not gonna let the prosecutor who's trying to prosecute my guy under the guise of treatment know things that they're gonna be able to use later on against them in prosecution. But that thought has to be competing against, well, wait a moment, aren't we now starting to develop prosecutors who are diverting and working with diverting? That's the friction.
Comment about that, because I've been a prosecutor for a long, long time. So I understand when you talk about the one side against the other, but I think times have changed. Times have changed, and mental health aspects of an individual are always mitigating in the case. There isn't a capital case, a murder case that we don't talk about. What is the mental health history? And it oftentimes is mitigating. So even though it's a very serious offense, the mental health is mitigating. So any defense lawyer who does not want to provide mental health, I think, is doing a disservice to their client, because it is mitigating. It's going to mitigate on the punishment. It's going to mitigate what we're going to do on the front end, the back end, everything. And so I understand talking about the continuum of care and where that came from, but I think times have changed.
Well, because like you said, defense counsel can provide that information, right? It's not as if they can't.
Part of the problem is defense counsel doesn't know that information.
Well, but they-
Oftentimes, it is the prosecutor who is providing that information to defense counsel to say, hey, did you know this about your client? And oftentimes they're saying, yeah, no, I didn't.
Oh, I think at this juncture, I'm going to turn it back over to Justice Bland. Invite continued offline conversation or with any of among any of the participants today, but to keep on track, I think we'll turn it back over.
Well, we've given a lot of food for thought to the people on your subcommittee and on your committee that are working hard on coming up with language, because it's always got coalescing around language that fits into a bill is always the challenge after we have a discussion of deep thoughts like this one. We're going to go ahead and break for lunch. It's a working lunch, so if you just would mind, take a few minutes to take a break and grab your lunch. And then we'll come back in and we'll hear from the Office of Court Administration. And then we also have a wonderful presentation on juvenile justice. So.
Outside or?
They're supposed to be here at 11:50.
Going to start with Commission Member Judge Renee Rodriguez Betancourt, who's going to help us facilitate the afternoon.
I can speak from here, correct? Sure. Again, my husband says I have a loud voice. I don't know why he would say that, but and my kids do too. So I'm assuming everyone can hear me. Again, thank you for the time for this opportunity. I do want to go ahead and take the time to introduce Dr. Scott Lepore. He is a husband, a father, a foster, and adoptive parent. And we just really found out that we're going to have our own support group because we both have 3 girls that we are raising. So we will talk about that later. Dr. Lepore, as a foster parent, he sought further training through Texas Christian University Institute of Child Development to help heal the life trauma of children from hard places. So life-changing that he now shows his training throughout lectures and workshops to foster and adoptive parents, as well as other healthcare professionals and various organizations and states. These principles also have become the foundation of becoming medical director of patient experience and physician engagement at the hospital where he works through building a culture centered around meeting the needs of others through trust-based relationships. Dr. Lepore is currently the medical director of the Texas Juvenile Justice Department and is using the evidence-based neuroscience of interpersonal neurobiology to implement the Texas model to their youth in need. He is also a member of the Texas HHSC Cross Systems Trauma-Informed Work Group and a co-chair for the subcommittee on screening, assessment, and treatment for trauma-informed care. Dr. Lepore.
Thank you. And I lost my co-chair, so I stood alone on that committee. But I just want to let you. I came here today to discuss trauma-informed model in the current neuroscience. Really not here promoting juvenile justice in any way. It absolutely correlates to what we're all doing. Just kind of sitting here listening to you all speak and the logistics and the barriers that you have, and I'm on other committees with some of the folks here, statewide behavioral health, coordinating council, things like this. So I see the logistics, I see the difficulties, the obstacles, financial resources. And at the same time, I've been exposed through complex developmental trauma training. Really, the answer sits in front of us and it's how to put it to word. So at least with what you're all doing, it'll give you some context to what dysregulation is, decompensation. You know, and I hear conversations until they get the meds right, these types of things. And I work closely with state hospitals, Jeffrey Matthews, Chief Medical Officer. And I don't want to be the bearer of bad news, but as the medical data is coming in and I get daily reports and domestic violence, self-harm, suicidal acts, mental health declination, like it's increasing at alarming rates. And the state hospital, when they would have a wait list of 10 youth, that's a critical state for them. They currently have 33, and it's going to get worse. So what I am here for, and I'll actually tell you how I got involved, but I'm here for the model. And that's why I moved to Texas 3 years ago. It actually became my passion in my life through my own life experience through the foster care system. So I'm a family physician. I'll kind of share how I became involved. My wife is also a family physician. We met in medical school. We got married and we were like, let's have kids. And our parents said, like, don't do that. And then we never had kids. And so for 14 years, we didn't have kids, but we tried. And so then my parents are like, what are you doing? So my wife finally gets pregnant. And in the 14 years, we talked about fostering, adopting, but we always practiced together. We just kept working. We were busy and it just never happened. So my wife said, I'm pregnant. I want to stay home. And I'm like, I get it, man. I do too. Like, stay home. We have the time, the resources. And so she stays home. And then it was about a year into it. We were like, man, we found out like the need for foster care system. There's 500,000 children in need of placement today. What are we doing about it? And so we were like, let's get involved. So we went through our training and we were exposed to, within the training, a book called The Connected Child. It was co-authored by doctors Purvis and Cross through Texas Christian University Institute of Child Development. And it's soft psychology, at least I thought so at the time. As a physician, I'm like, this is psychology, I don't need this. And I've got the medical model, I've got traditional parenting, but it seems nice. And for me, soft psychology as a physician was like a kicker on a football team. You use it if you have to, but it only gives you 3 points. It's not much benefit, but it's there. And if you need it, you use it. So we finished our training, and then the state actually came to us and said, we know this is your first placement, but we have a big ask. We know you guys are both physicians. We have a foster care family. They're closing their home. They're not taking anymore. They have 2 siblings. They're fearing for the safety of their own biological children. We need to split the siblings up. Will you take, it was just a 4-year-old. She's about to be 5. She was a big girl, but will you take her into your home? And we think that because you guys are both physicians, you could probably do the best help for her. So we were a little nervous, but we took her in. And so we thought, man, we've got the medical model. We were both family physicians. We were trained in parenting, and we have traditional parenting, and everything we tried failed. And it got worse. And finally, to the point where my wife, we were in bed and just talking at night, and she was in tears and said, I don't want to wake up tomorrow. I can't do this. And I said, well, we tried everything we could, man. Right? We offered this girl help. She just didn't receive it for whatever reason, but let's just be done with it. And so Rochelle was like, you know what, can we at least try that connected child that we were supposed to? I said, sure, let's give it a chance. So immediately we had a connection with this girl. She started to change, which it fed on itself. I went to a conference, this Empowered to Connect, and it was all about the connected child. And I learned more, and I was sending notes to my wife. And so within 6 months, this child changed. And so the state came to us, and we had CASA worker, case manager, consultant, everybody you could think of in that room. And they said, we have our answer. Will you guys help us recruit physicians into the foster care system? And I said, sure, we can, but that's not what helped this girl. So I shared the principles of current neuroscience. I applied for a scholarship, went to TCU, became a practitioner in the model of trust-based relational intervention. And I'm not here to promote that either. There's other models. It fits within a field called interpersonal neurobiology, is the current neurosciences. This was fielded by a Harvard-trained neuropsychiatrist, Dan Siegel. And he's not the one that invented the field either. There's others in the field at the same time working independently, like Bruce Perry, Peter Levine, Bessel van der Kolk, these pillars of trauma-informed care, but it was all coming to the same conclusion. So I became an educator. I started to teach foster adoptive parents through organizations, started to implement it in my practice, right? So at first, foster children in my practice. And then I'm like, my gosh, this is really optimal connection for all ages, all relationships. Then especially through Brene Brown's work coming out of Houston, right, with empathy, vulnerability. And I'm like, man, this is for all age groups. So I started to implement it in my practice period. The hospital actually came to me, and I was actually on my way out of the hospital. I was in a bad situation. They had made all these budget cuts, and I was actually about to sign a contract with another hospital, and I was unhappy. So were my nurses and other physicians in the system. So they actually fired the associate vice president of the hospital. They brought in this new gentleman who came to me, and he said he didn't know I was about to leave, and he said, Scott, you've gathered the nickname of Unicorn. He said, you're the most productive family physician. You're the highest rated with patient experience. And he's like, can we breed this, or what are you doing? And I said, I can tell you exactly what I'm doing. It's not me. I wish I could take all the credit, but I'm applying this current neuroscience of connection. And so it's logical, actually, when you go through it. It's not cultural. It actually opposes what we know culturally and how we connect with people. But once you understand it, it becomes logical. So he said, will it work for our physicians and patient experience? I said, absolutely. Science says it will. So I became medical director, started of physician engagement and patient experience, which, as you may know, but hospitals are now being paid on how well they're rated by their patients in part. So it's very important. The hospital currently was at 20th percentile for both provider satisfaction and patient experience. This gentleman, and actually he's in a picture I've got, and will the presentation go up? He started to implement this, and I said, we need to start with administration. It's a caregiver model. It's actually not changing the person you want to change. It's actually changing the way you connect to the individual. So we started to teach administrators, but he started to implement the principles right out of the gate. In 2 months, we went from the 20th percentile for provider satisfaction to the 80th percentile. And in 18 months, we went to the 90th percentile for patient experience. So it is just simply the model. So I started to then get asked to help other states with foster care, trauma-informed care training, and kind of giving them answers on how to navigate through foster care difficulties. In November 2018, I was asked to come testify to Texas state legislators on trauma-informed care and foster care. And so I testified first. I had to give a lecture that afternoon at Texas Christian University. And they let me testify first. I testified with Chandra Carter, who was at that time the Deputy Executive Director of TJJD. And she's very trauma informed. So we connected and she said, will you train our medical director? So I connected with their medical director, started to help them along, and then he retired. So they asked, hey, would you consider coming to Texas? We want to implement what you know, and not based upon what I know, but it's the same model. Would you consider taking that position? And at that point, it become my life. And so absolutely, we moved and came here. So I'm here for the model, for the science, because I see how it helps children and actually it helps all of us. So it may be how we're implementing it in TJJD, but I'm not here to promote our agency. So no matter where, but I'm thankful for our agency that they are utilizing it to help any child that does come to us. But no matter what agency that I go to, and actually my goal for the state of Texas is to learn and implement these principles to help all of our youth in need. And actually it includes all ages, so even adults. And that is how I became involved. And I'll just say up front, like I'm gonna hustle as fast as I can. Usually I have to hustle to do an overview of trauma-informed care, and I hustle within 90 minutes. So 30 minutes, I'm gonna do what I can. I'll do the best I can with the time I have. But we'll skip a lot, but I'll at least mention that this is a pivotal point, and maybe learn more about it. Oh, wait, I'm changing it there and up there. Thank you so much, Renee. So everybody's probably familiar on this group, I'd say, with ACEs, Adverse Childhood Experiences, right? Dr. Felitti, Kaiser Permanente. If you know the story behind it, it's pretty interesting. Dr. Anda, CDC comes in, psychiatrists, I think, were the first conference that this data was presented to, and they poo-pooed it and said, okay, that's just an excuse for people's failures in life. And Anda said, you've got great data here, you need numbers. So Anda gave him numbers, and then we came up with the ACEs study, which is pivotal. And so they looked at abuse, neglect, dysfunction up to the age of 18, and it's a 10-point questionnaire. What I hear all the time is, and hopefully we can get to it to where I talk about effective models of assessment, but people say, wow, now that we have the ACEs questionnaire, we don't need the psychological evaluation, right? And I'm like, well, so the ACEs are pivotal. It doesn't take into account frequency, severity, duration, chronological age. It doesn't take in resiliency or buffers of connected relationships. And that's what we were learning is the most effective developmental factor for neurological development. So actually, when you assess risk, a better predictor is their level of connectedness in their childhood as opposed to the level of trauma. And we're gonna find out why. But it's great for large group data. So if you do have someone that has, let's say, greater than 4 ACEs, you can assess for that group what your risk is for difficulties, and actually even biological factors in adulthood. And the mean currently is your childhood biography will largely determine your adult biology. Even things like primary brain inflammation that we thought never existed other than from infection or blunt head trauma we now find actually exists as a primary source from childhood trauma. So systemic inflammation is a very significant adverse effect of childhood trauma. So this was the ACEs study, but here even like that last suicide attempts. So this is what the ACEs study showed. Like this was the pivotal thing that got people's interest. But if you had the first column actually assessed no ACEs, that second column for that data is 3 ACEs. The third column is 7 ACEs. But you see if someone claims no ACEs, their chance for suicide is 1 in 96. Of those people attempt suicide. You have 3 ACEs and now you have 1 in 10. And then you go to 7 ACEs, 1 in 5. So that's doubling. And then there's expanded ACEs, right? So not all ACEs are ACEs. So that is also a limiting factor with the ACE questionnaire. But we find that generational trauma, racism, where you live, growing up in foster care, these types of things also contribute, and even just emotional neglect. And actually, you know, one of the things that, and I think I put the slide in here twice for this point, but when you hear, so that I'll also discuss too, like if you know the whole narrative of trauma and you learn it in the context, in a big picture, you can stay on track with effectiveness in your decisions and legislative decisions or therapeutic decisions. But where people run into trouble is they lose the narrative. So here, without understanding the big picture, so they look at, wow, the traumas are detrimental. That's what really affects you. And if you think about it, it's not just the trauma, but it's the absence of relationship that should be there. And that actually is what is more pivotal. So it isn't just that I have a father that's alcoholic, beats my mother, threatens my siblings, but I'm also not getting, and we'll talk about this parasympathetic connection that's healing, shows me what love is, brings me value. I feel valued in life. And I know how to respond with effective tools and relationship to other people. So you actually have 2 factors here. You have the absence of plus detrimental effects, but they're separate and they matter. So when you talk about trauma in the brain, you probably hear most commonly like the 3 aspects that we talk about. The prefrontal cortex, that's the part that develops last or matures last. And the human brain develops, or matures, I should say, because it's continuous through life, that you can change neuroplasticity. But the mid-20s is when your brain matures. So it's interesting, like age-wise, these juveniles don't even have a fully developed brain, and that's under best circumstances. And then here, and it's interesting too, like if you get into neuroscience, but the anterior cingulate cortex really is the God part of the brain. That's where empathy, compassion seem to be located. Then you have this dorsolateral prefrontal cortex, not on there, or the orbital frontal cortex, but they work in orchestration to give us decision-making, rationalization. So let's say someone cuts me off the highway and I get PO'd, I react, and that would be, we're going to talk about the midbrain, but my safety's threatened, so I become reactive. But I recognize my anger that brings me back to the prefrontal cortex and the dorsolateral prefrontal cortex. And then I think about, I'm going to go ram that guy, right? The thought comes to my mind, but I've got my children in the back. And then I rationalize and I reason and I calm and I self-regulate. I can actually get, if I have a well-developed anterior cingulate cortex, that, man, you know what? Maybe that guy's on his way to the hospital and I shouldn't have gotten mad anyways. I hope he's okay. So I actually end that event with compassion. So how a person gets there is how developed those parts of the brain are. Like this is what becomes pivotal is you can't court order that. Like somebody has to come in and develop it. So it'd be just like with golf. If I am a bad golfer and I get court ordered to be a better golfer, but no one takes me to the driving range, it's impossible. Or even so what we find is that what my parents tell me to be, let's say my parents tell me to speak French my whole entire childhood, but they're speaking to me in Spanish. Guess what language I grew up speaking? Spanish. And that's what we'll talk a little bit about attachment, but that's what attachment shows. I will not become what my parents want me to be, tell me to be, preach at me to be. I will become who they are, period. So it becomes a caregiver model. And I don't know if anybody here is a dog lover or loves Cesar Millan, the dog whisperer. Right, that's his meme is, I train people, I rehabilitate dogs, because science shows it's within nature as well. So he doesn't try to fix the behavior of the dog. He changes the pattern of attachment from the caregiver. Once you do that, the dog will self-regulate. And actually, when you have a dog that has severe behavior issues, he may send them off, if you ever watch the show, to a very healthy dog pack. And then they rehabilitate the dog back to normal dog behavior. But it's all about the caregiver. It's a caregiver model. So there's hope in that anyways. When I hear about on these committees, like funding, we don't have the resources. Well, actually, if we utilize the people we have, the funding's not as much as you think it is. But the most important factor in successful caregiver is the caregiver making sense of themselves and how they connect. And it's the least known factor, and it's the most rejected factor. And I believe it's the least known because it is the most rejected. Just like with patients, they'd bring in Johnny with ADHD, and I would ask, well, how is it at home? And not that it's the only, there's a multi-complexities with ADHD, but I would try to find out what's the environment of the home. I don't know why you're asking me, Doc. I mean, I know I'm your patient too, but we're here for Johnny, not me. Well, it actually involves you as well. So we actually talk about the midbrain, and that is like the watchdog. It assesses for safety. Every time that's triggered with danger, it becomes more heightened. Let's say that we're here talking right now, and hopefully I've got you in the prefrontal cortex, and you're paying attention and focus. But let's say we hear some popping in the distance. And depending on your experience in life, let's say you start to recognize that's an active shooter. I think those are gunshots. So then your midbrain, once it recognizes it's a threat, it will detach the prefrontal cortex. So once you believe there's an active shooter on campus, I can keep teaching, but you're not going to learn anything, right? The brain is now going to send you brainstem, which is that fight, flight, or freeze. And you're either going to fight the guy, you're going to run, or you're going to hide somewhere. So let's say that happens. We call the police, they come, they get the guy. It only lasted about 20 minutes, but we're all right devastated. Would you ever forget that? And you wouldn't, right? For the rest of your life. And even if you did forget it with implicit memory, your brain would never forget it. This is why we see children that go through difficult experiences. They don't have memories, right? I'm 2 years old, mom's cooking spaghetti. My dad comes home drunk, beats up my mom, threatens me. I don't ever remember that. But when I'm older and I smell ragu and I'm like, I don't know why, but my heart rate goes up and I get a little anxious. Well, you don't remember, but your brain does. So what fires together, wires together. So everything that it remembers about that event, it takes the data in and it goes, oh man, I smelled that, you're not safe, right? Even though it has nothing to do with safety, it's all wired together into the brain. So like with the active shooter, we would never forget that event, and it altered me because now if I hear anything close to that, I react faster. So that's a one-time event for us. How about children that go through that repetitively on a daily basis, right? So what happens is you overdevelop, you have a overactive fear system. And so what happens when that is engaged all the time? Guess what is not engaging? The prefrontal cortex. So now you have, and then we'll talk about, so the limbic system, brain system, like the brain or the brainstem is almost completely developed at birth. And that's why your child comes out and it's able to cry when it's hungry. Can't do your taxes, right? That all comes later on. And then the amygdala is that kind of, we already covered, but it's that part of the brain that's always assessing for fear, for safety. And so your body's prime objective is to keep you safe more than it is to keep you happy. So it's always assessing. So the more that is triggered, developed, it's always going to be more on an alert than an individual that doesn't have the historical trauma. And so this is where we come to, right? This is what we all want for the youth. So the area that prefrontal cortex, right? Complex thought, reasoning, self-regulation, behavior, judgment, all of these things that we want come from the prefrontal cortex. And so it can only be trained. So let's say we do get a caregiver that can engage with that youth in a way that's productive and integrates a well-integrated brain. They have to feel safe. And it's not cognitive. It's not that I tell you you're safe. Just like with foster children, right? This is what we learn is that, what can I do to make you feel safe? And so, and then looking at different mechanisms, and that's a whole nother topic as well. But the importance is that if we want to actually establish implicit trajectory for these children for success, they have to feel safe. And if they don't, if they feel threatened, you're not going to engage that part of the brain. And it's true for all of us. So just like if I was up here, and I love what I talk about, but let's say I was scared to death to be up here, more than what the mission of what I'm talking about, I couldn't think, right? I can't think of what to say. It's all because I'm in a fear state. And so I can't think well. And then the presentation's over. I'm like, man, what happened to me? Well, I was in a fear state. And so the part of my brain that usually discusses these things is now offline, or it's fighting to stay online. So really, I love this model. This comes from Dan Siegel, Tina Bryson, and their work, mostly with parenting. But really, the brain is a construction. And so if the basement is like a brainstem, right, it's developed. But all the wiring and the framing, so you do start to work on the prefrontal cortex, even at birth, but there's the framing of the house, but it really gets developed from the bottom up. And then it's till the mid-20s that it's actually completed. So if you think of the construction of the home, the reason why I love this model is that it isn't just traumas that affect that home, right? Because this is the old thinking, even medical, right? And medical model does not have this in its mainstream teaching yet. It needs to be. It's rewritten the DSM, like it has rewritten psychiatry. It also is rewriting mainstream medicine. But it's also, so my builder, who's constructing my home, what resources do they have? Not financial, but relational, emotional. So what is the constructional value of my home and the stability of my home? Now, let's say I have an extremely well-built home and I had a great caregiver that had resources and skill set, and I have traumas. I'm probably going to be okay, and I probably still have a functional home. But what if I have traumas and I don't have a well-constructed home, right? I didn't have a builder that built me a nice home with resources or a skill set. I'm in trouble. And how about even if I don't have traumas, but no one really developed me a home, I'm still in trouble. So this is where we find some people may have a low ACE score, but man, they just really struggle. Well, you shouldn't be struggling. Like you had a privileged life. Not necessarily. So again, right, attention, behavior, judgment, emotional responses, that's all part of the brain that we want. And we find that it all comes down to this. And I'm so far away, but I think even just covering this, and maybe we can hit a couple more points, but it all comes down to the attachment cycle. John Bowlby, his work in the 1940s, again, was soft psychology, but he had thousands of behavioral studies. Like there was a lot of data. So out of even the soft science previously, now psychology is a hard science, right? We have functional brain imaging, neurotransmitter profiling. Now, like you can pop the hood on the car and look at the engine. So this is different than previous observational studies and questionnaires. We have hard data now. So this is why we go back to John Bowlby and go, holy cow, he was dead on. So this is where if I'm a child and I'm born, I express a need, right? That's sympathetic nervous system, excitatory neurotransmitters. And then I have a caregiver. And let's say that caregiver is attuned to me and knows the need that needs to be met. And that caregiver comes and meets the need. And let's say it's optimal. So not only do probably like I did, oh, my daughter's crying. Unfortunately, I changed, but here's a bottle. She stopped crying. I'm going to go back to what I was doing. This engagement actually is, I feed you, we connect. It's a very emotional attachment within that connection. really peaks the wiring of the brain, dopamine's released, oxytocin, serotonin, all these wonderful bathing neurotransmitters. And that brings parasympathetic and calming neurotransmitters. That's what starts to construct that brain and wires that brain. And that happens 1,000 times. So then the baby grows up, and then now I'm 3 and I want a glass of milk. And then I'm 10 and I go pour a glass of milk. That's scaffolding the brain. So repetitive actions train the brain to be what it needs to be and get through life. So I have a difficulty, but now I know how to get through the difficulty. And as Stephen Porges says, human connection and co-regulation is the biological imperative. Like, we are designed for connection, and we have to have it to be fulfilled humans, not just safe humans within communities. But let's say you have the same child, and now I have a reactive parent. They didn't have really a good childhood. They don't have good parent skills, and they hear a crying baby, which is a trigger for the brain. It's an aggravation to the brain. And so they either go, they don't have they have a disintegrated brain, meaning like there's not good integration with the prefrontal cortex. And it's amazing like how that connects all in there, the midbrain, the brainstem. So when you don't have a well integrated brain, you easily can flip your lid, like the language we use, but you disengage that prefrontal cortex. Now there's no hope for making that judgment until someone calms me down, or I calm down over time. But let's say I flip my lid with that sound. Right, what engages brainstem? Fight, flight, or freeze. I'm either going to hurt that child. Maybe I do drugs, or I shut down, or I'm out of here. I'm done parenting. This is not for me. Right. So then what happens to that child in need? They're still in need, and they'll eventually stop crying. But where are they? Brainstem. So what's developing? What becomes overactive, hyperactive, overdeveloped? Brainstem. So now I grow up, and now you can see where the brain of the parent becomes the brain of the child. And now I go through life reactive. Someone pees me off that most people would walk away from, but I deck you, or like I react, and I may even regret it later on, but I'm a very reactive person. Hey, Christy, just let me know when I need to stop, because I think I'm almost out of time. We barely hit. Sure. So, and this never goes away. So this, but by 12 months of age, your attachment style is going to be set by the caregivers you have. And most commonly, it's going to be set for life, unless someone of significance comes in and changes your attachment style. But it never goes away, right? So it creates independence, and it creates also, when it's optimal, of coming back to a parent. And man, if I had time, actually, when I get asked to do trauma training and I get to pick the topic, I hit attachment every time, because it's the answer to the problem we all deal with. But it's how, so you can have non-caregivers, but thousands of interactions with different people. And if they're all that healthy connection, co-regulating, you can heal the brain of a child. So there's the therapy, which is why we see in the animal kingdom, they can heal without therapists, getting appointments to doctor's office. Not that that's a bad thing, right? It's what I do. And medications can be a bridge for more effective therapy, but it'll never heal the brain. But the therapy will, the connections will. But it never ends. And then there's that guy, there's me, and I'm complaining. Let's say I'm a physician, the EMR goes down, and I got all these patients. I call him up, and he says, I could care less, man. You got patients on your schedule. The hospital needs to make the money. If you don't see those patients today, Scott, you can just kiss your job and you might as well go home. Right? Disconnecting. He leaves me in my distress. I become more distressed. How do I start to treat my staff? Distressed. And then what do I start thinking? I'm out of here. Like, so this all becomes for job satisfaction. The model extends into life in complexities you would not believe. But let's say he says to me in a different way, I have my need. I call him up and he says, Scott, don't worry about it. I'm going to call IT right now. How many people you got on your schedule? Let's cancel the last half of your afternoon, and then we'll work from there. Try to do some people on paper. Right, the difficulty doesn't go away. It's not about removing difficulties. It's about how we work through them. And so when he says that, I'm like, oh my gosh, thank you. Like, I'm going through a difficulty, but I love this place, and I'm not leaving. Like, they help me, and I actually get more done than I actually thought I could, and I get through it fulfilled, because of how I'm engaged in my distress. But it never goes away. So the 4 pillars of secure attachment. So we see that those that do most successful in life, not necessarily make the most money, but do the best in their employment relationships, they tend to have skills of being able to give care, receive care, both in healthy ways, negotiate. And negotiate here is not I win, you lose. I'm great at negotiation because I hear that a lot. It's like I win, you win. And when we're done with it, we're both closer connected. And then okay with autonomous self. So in relationships, we come and go as needed. If you need me, I'm here. If I need you, we're here. But then we also fall apart. So it's not intrusively, I'm connected to you and needy, nor is it that I avoid and I do everything on my own. So that's what we see with secure attachment. So the therapy becomes everything that we know about secure attachment. So my model is trust-based relational intervention. There's more models, but it's all keeping the brain safe and then engaging in that way to help co-regulate, but it's giving the brain skills to be successful. You can punish the brain to change behavior. Kim Jong-un, if I say it right, is doing that, right? You can create fear to change behavior, but it doesn't implicitly change the brain where it needs to. You're not changing that person to be a more fulfilled, better person. You're actually changing behavior out of fear, but you're not helping the individual. So maybe I stop there. But I didn't even get started. But yeah, for sure. So, man, I think they are up to about 600 trained people with TBRI. And again, you can't tell people to be the model. You can train them to be the model, but there's a lot of work in becoming the model. And some people, they don't have to go that far, right? They're natural at it. Man, if you go across our campus, youth development coaches, and thankfully, like we have a crisis stabilization unit. I was going to go to that, kids with the most aggressive needs. And we have the best trained people, but they also have the skill set. So I would randomly go to assess like our crisis stabilization unit. And that coach is so connected with those kids. So these are the most needy kids, worst behavior kids on campus. And they're connected, they're doing projects, they're building trust. They had, man, maybe I shouldn't be sharing this. I'm glad Sean's not here. But like the coaches were tied up. Of course, they have a coach watching, but it was all trust. They're tied up and blindfolded. And the kids, the worst kids on our campus, were the ones working as a team to set them free. And they were telling the coaches where they needed to move and what they needed to do. Like it was amazing. So then I randomly went to other dorms, and maybe they're just watching a movie that probably isn't even the best movie to watch. Like they're just babysitting. And so this is what we're trying to get is that, but so then I can't necessarily be judgmental to that person because they're using the skill set they have, right? This is probably how they were raised. Like, yeah, my dad and I were together, we watched TV. We didn't talk much. So what's going to be uncomfortable for them? Engaging that way. And so this is what we learn. We have to make sense of who we are and then lean into our own discomfort and become and acquire those skill set that will naturally not be comfortable for you if you lack that. And I did that as a parent, right? As I had to lean in my own discomfort because I wanted to be a better father once I saw what optimal connection was and how it changed my relationship with my daughters.
Sounds wonderful, but it's short term, right? Because once they move, they're going to move back into one of the other campuses with people who are not trained. So how do you continue to instill the training to actually change the brain so that it takes, because it's like it's 2 months or whatever, 60 days, whatever it is, if they're in that crisis community, it's kind of enough.
Yep, and I didn't mean to make it sound like they're all the other ones are not, because we have many people trained, but it doesn't guarantee that once they go through a training, right? It's like I get trained on how to golf. It does not make me a great golfer. I have to go out to the driving range and start hitting balls. Like I have to put it into practice. And I may have some natural skill set, so it's going to vary across the campus. But there are those that won't have the skill. But I'll tell you the model, and this is what I talk about in groups. or the committees that I'm on, is that the model needs to be, I don't care where these children get sent to, but the effective therapeutic model is what the science tells us.
Explicitly training these young people, in other words, telling them this is what we're doing? Or are you just doing it? Because it seems to me, to sort of address your question, is that if you're training them, you're empowering them with the actual academic, intellectual approach that you're doing.
Yeah.
So that if they're in a situation where they don't have that support, they're able to at least say, well, you know, I'm not a PhD, but I kind of learned some tricks or some skills that maybe I can apply here.
Yeah, and we've been implementing that last year, is getting up posters. I actually am on a small work group within TJJD that's doing that. So they start to understand the brain and understand why when they dysregulate, and that's the effective treatments too, like learning how to co-regulate so that they can self-regulate, but giving them the skill sets. And it can be as easy as like name it to tame it, meaning that, let's say I become angry. I disengage from my prefrontal cortex, or I'm struggling to disengage. If I simply name the emotion I'm having, the part of the brain that allows you to name it is in the dorsolateral prefrontal cortex. So what have I just re-engaged in a stronger way, the prefrontal cortex? So just recognizing my own emotions. So we have nurture groups where we're effectively doing this as well on a regular basis, along with treatment. And I got to tell you, like, I don't want to romanticize, like, we have a long way to go, but this is the daily, is how do we get there? If the state changes it and the model and how all this works, fine. I'll go wherever we're implementing this, because this is the effect. It's not what building you're in, it's how you're treated while you're there.
There are models or theories that at a certain age, early, like 7, you're set for life. You know, brain wise and wired wise and all of that. So is it ever too late? And then if something triggers you, can you revert all the way back to, you know, before that?
So think of construction of the home as the more construction you have, the better you'll do with triggers and responsiveness, co-regulation, self-regulation. So attachment style. So there was a lot to unpack there. So I hope I didn't confuse you. Attachment style set by 12 months of age, and can change. And that's from the interactions with your caregiver. The brain never stops changing. That's the hope of neuroplasticity. There are studies that suggest that it takes about 1 month per year of age for change in optimal setting. So that's why with foster care, that girl was able to change within 6 months. Now she went back to a detrimental situation. And then what my wife and I started to do is wrap around the family, the biological family, so that we could help them, because there's the answer. It's not, and I'll tell you, like, and I wish I had more time, because what you guys will get hit with is maybe these political things where, let's say so caregiving models of authoritative, authoritarian, permissive versus neglect. Like if we put that out there, but you see, this is where we get into the pitfalls of where we want high structure. So the model is high structure, high nurture. Like if I could sum it up, it would be like, we do have boundaries. The boundaries are not here to separate me and you. The boundaries are here to keep relationships healthy. But if you ever break a boundary, I will never harm you, shame you, intimidate you. I'm always here to help you, protect you, and guide you. Now it's up to the choice of the individual to connect. But the better skill set of the caregiver, the better the connection, which is why we have Cesar Millan, right? Nobody can help these dogs, but this man who has an incredible skill set to connect can help. And so that's how he became known. Like he could help dogs no one else could, but he also understood the model. So it does seem to decline into adulthood. Again, the time thing, but also is there a pivotal point of no return? Potentially. Karen Purvis, who co-authored The Connected Child, seemed to believe that there's no lost hope for anybody. But I don't think that answer's out there. I'm hopeful too. Maybe that there's hope for everybody.
do while the child is at TJJD with the family so that when they return to the family, they're not thrown back into that same traumatic.
So we're working on that. And we're not set up for that, but since we recognize the need and we're doing it in small ways, like it's in some ways we're super effective. We're like with treatment, it's incredible the amount of treatment we have in the neurosequential model of therapeutics. We're implementing EMDR, DBT. If you know psychology, these are the silver bullet treatments for trauma. But in other ways, what we're trying to do, maybe teach the youths as much as we can, help the families. I actually educate on attachment. And we offer the parents, and this is the side I don't know is what you all do, but we offer the parents or caregivers an opportunity to diminish the length of stay if they participate. And so we train them on attachment and skill sets for the parents to make sense of their own past. And so what the science strongly suggests is people do the best they can with the tools they have. Everybody wants to be a great parent. But we all fall short in some areas. So we work on those skills and train in a way that's palatable and digestible for those folks.
Just on that, have you guys looked at the work of Stuart Avalon and the collaborative problem solving approach? Because it really comes out of the same thing and it's a parent-based training thing. Have you guys been looking at that at all as a way to kind of export this to parents and families?
I don't know that they've looked at the specific model.
So it might be a good connection to have, and they've really been able. It's pretty cost effective, and I think at this point they've 100,000 parents they've trained, and it basically takes the part you were talking about around the negotiation piece and puts it in this sort of frame and teaches people skills on how to do that. It teaches the parents the same skills so that they can then do that with their kids.
Yeah. Thank you.
Comment. I too am a TBRI clinical practitioner, and I've also been a psychologist for 37 years. So when I went to the training, I thought, what is this really going to add? And it really has significant addition to what we do. We use it with children involved in CPS, so young children. We have an infant toddler core project, and we're also looking at expanding it to children of incarcerated parents.
That's awesome. Yeah, and I'll tell you why it's so opposable, even though it's the silver bullet, is because, and people will look at it and go, oh no, that's great, I could do that. I think I actually already do that. Because we are a behavior-focused society, largely. And so the principles of TBRI, or just interpersonal neurobiology, but it's that I'll empower you, means I'm gonna help you with your needs. And then the next principle is to connect with you. Like we become relational. And that happens. So when I meet someone's needs, the brain senses safety. And by the way, sex predators will use this to their advantage, right? I'm going to meet your needs, sex trafficking. Now we're going to connect and you trust me, but now I'm going to use you. So it's the opposite. But the optimal model is, so I meet your needs, then I connect with you, and then and only then can I truly implicitly guide you. And that would be the correction part. But I'm rewiring the brain through safety and connection. But culturally, if you think about it, we are behavior focused, meaning that, well, Renee, if you change your behavior, maybe we could be friends. And once you change your behavior, and I'm certainly not going to meet your needs, right? She deserves everything she's getting. But if you change your behavior, maybe I'll connect with you. And actually, okay, now that I kind of think I like you and through the connection, I'm gonna meet your need because you're that special. But it's actually the opposite. So we're very selective of who we get in to meet their needs. But the science shows it's the opposite, right? You have to, those are the hard things, right? Brene Brown brings it out in her work, not even TBRI-ish, but to stay out of judgment, perspective taking. Assessing the emotion in another person and then relating it within myself so that we can connect. They're very different than what we do culturally, even though it's logical. Yeah.
Information. I'm not gonna take up much time. I think we covered a lot of what I see every day in my court. Again, I'm Judge Renee Rodriguez, setting court. I'm the judge of the 449 District Court. My court, or the 449 District Court, was created about 10 years, maybe a little over 10 years, specifically as a juvenile court. So I preside over all juvenile detention hearings in Hidalgo County. Hidalgo County, to many, some believe in rural, it's not anymore. It's actually over 1 million population. And we're not even counting those that probably weren't counted due to them being so close to the border of Mexico and being afraid of their immigration status. They probably participate in the most current census. So we are about, I think, a little bigger than Denton County. But the bad part about that is that we're still operating in the juvenile justice system in our county. We're still operating like we were operating 30 years ago, where the traditional juvenile judge would come in, hear the case, assess the information, of course, make sure that, applying all the legal issues, and then providing their decision, placing them on probation, making sure probation officers are supervising them, or if not, send them to a placement, or if not, send them to TJD. Very 1, 2, 3. That was traditionally what juvenile judges did. I am coming now, and when I got elected back in 2017, I came in with a lot of ambition, thinking that I was going to change the world or change the juvenile justice system, because I saw so much that was happening and things weren't getting done to help these children. I don't believe in a punitive type of setting in my court because they're children. We're not dealing with adults. These are children, just like Doctor said, they have trauma issues that no one has ever discovered because they've never been evaluated. They have mental health diagnoses that have been undiagnosed because parents don't understand, or culturally in our area, which is predominantly Hispanic, it's a stigma. We don't talk about that. That's not what we do. And so a lot of the children, during my 6 years I've been on the bench, it would take until they're in front of me for us to actually get a psychological evaluation and see those diagnoses. And then say, okay, what are we gonna do now? What's the next step? So now as juvenile judges are rising, I think not only here in the state of Texas, but across the United States, I think it's more of not only a combination of judicial, but it's also administrative collaboration and advocacy as a juvenile judge. It is important that we advocate for what we see in our courts. Of course, a lot of times our courts are not privy to the public because of the confidential information of the minor. I know a lot of the defense attorneys in my court ask for it to be private, and I do a one-on-one type of case setting for each child, because I want the child to see that I'm listening, that they're watching me, they're understanding that I'm not just, telling them what they're doing wrong. We're talking about the good before we talk about the bad. And so in that line, I believe as a juvenile judge, it is our duty to advocate, to go out to our communities and to talk about the issues we see. And one of those main issues is mental health. And I tell you, it is attached to any situation that this child is involved in. And then it also goes into the home. Any model we talk about, we can talk all day about different models, but if it's not working with the family and the child's going to continue coming back into the system. And ultimately, the child is going to go into the criminal justice system as an adult. I'm not a scientist, I'm not a doctor, but just sitting in my bench for these past 6 going on 7 years, I see it over and over. I see parents coming to my court and telling me, he's bad, he's in trouble, I can't handle him, what can you do for me? And I sit there and I say, okay, let's go back. First of all, tell me something good about your child. What do you mean? I said, you just told me everything bad about him. What's good about him? And they take long to answer compared to when you ask them, okay, what's going on? And then I go, okay, so what have you done for your child? Well, I yell at him. No, ma'am. What have you done? Have you taken him to a psychologist? Have you talked to his teachers? Well, no, he's failing all his classes. Yes, I'm sure he is. But did you ask why? Have you spoken? Is there communication? And then they turn on me and start looking at me like the bad guy, saying, well, you're here to punish them, not punish us. But it doesn't work like that. And I know, because not only do I sit as a juvenile judge, but I'm also a parent. My daughter during the pandemic was diagnosed with anxiety and depression. She entered middle school without even covering two major grades, 4th and 5th. And now I'm getting phone calls every month from the school asking me to get there because my child is either misbehaving or at one point she was even cutting herself at school. So I know as a parent what the role is as well. And I didn't blame my child. I went and advocated for her. She was getting in trouble because the teachers didn't understand what ADHD is. Teachers weren't understanding that a child can't sit still, listen, sit still and don't talk. Doesn't work. It doesn't work for every child. It's not traditional as what we were growing up. So those are things, again, that I've not only experienced as a parent, but I've experienced now as a judge as well. And so I guess being here is a big honor for me. And I want to thank Justice Harvey and Justice Van for allowing me to speak today. And it's a big honor because I think there's so much more we can do. And it does start in addressing these issues with our youth and the family. Because then we're going to be here every single time talking about the same issues of overcrowding jails, rebuilding prisons. It starts with our children. And ever since COVID occurred, those numbers are rising. Trust me, I have right now sitting, waiting for certification hearings in my detention center. I have six murder, accused of murder teenagers under the age of 17. And for me, where do we fail them? What more could we do? So there's so many resources out there, but as judges, especially those who are juvenile judges or hear juvenile cases, it is important that we think outside the box. It is important that we go outside our four walls. And it is important that we utilize all these resources to help those children and those families. Doesn't matter if you're a big county, a small county. And so I'm very happy to be part of this commission because of this, because I know we can make a difference. And I just want to share my own personal experience on the bench because it's not getting better. And as much as I hate to send kids to TJJD, and we spoke about this, I think all these types of practices need to come before. We need to be proactive instead of reactive. And I think we can, and I know we can. Even to the point, and I'll end it with this, even to the point where we have JSOs who are just coming out of high school being hired to supervise these children in detention. You're having, and without even them even being, when you're a police officer, a DPS officer, they get psychologicals before they're even entered into an academy. We should be doing the same when we're dealing with those that are taking care of a child, regardless if they're in a detention type setting. So again, these are just some of the things that I see that I've experienced. And I want to say thank you again, Christy, for allowing me to speak. I don't want to take any more time. I wanted to give a lot more time to our doctor so that he could explain some of these practices that are vital and that we need to start incorporating, not only in our juvenile justice system, but even early childhood as well. And one more thing. It was Frederick Douglass who said, "It is easier to build strong children than to repair broken men." Yes. I should have ended it with that, right? I also want to take the time to thank everyone on the commission and the collaborative council who's doing the hard work at the intersection of law and children's mental health to build strong children. And we do have a list on tab 6 of our agenda book. There is a list, a nice list of all those individuals that we want just to go ahead and we can have a round of applause for them and just recognize them. It is in our tab. The one with the colorful. Yeah, it's the last one. It's the last one. So we're gonna have I work personally with, I've had the honor to work with, and I know that they have, we're on the right track. So thank you.
Thank you very much. And now hear from Megan Lavoie from OCA. I know she's running in about 500 different directions. So
yes, thank you, Judge Hervey. I'm sorry I missed my slot this morning. We had our Texas Judicial Council meeting. This morning, and happy to be here with you now. I just have a brief update from OCA. So you probably have been hearing that our court system is facing a significant backlog due to COVID-19. When defining the backlog, we're using the total number of active pending cases as of March 1st, 2020 versus the total number of active pending cases. The most recent data we have is March 2022. At the district court level, the backlog is roughly 157,000 cases statewide. At the county court level, the backlog statewide is just over 30,000 cases. 70% of the total backlog is in roughly 20 counties in our state. That focus on the top 20 counties is important. The judiciary in the third called special session last fall, we received $7 million to assist in the court backlog due to COVID-19. That money was recently transferred to the judiciary, and we're focusing on the top 20 counties at the district level. We've sent out a letter with an action plan, and so counties that want funding to assist with the backlog have to submit a plan to our office, and we're going to go over those with the regional presiding judges as well as Chief Justice Hagt and Judge Sharon Keller. Those plans are actually due today. Just as I was sitting here, I got about 5 of them in my inbox. So we're eager to get that money out and to assist jurisdictions with that backlog. We're also working to contract with the National Center for State Courts to do case flow management training for judges across the state. And so we are hoping to have a 1.5-day summit where judges and their staff will be able to come and get that training. We're also looking to have an option virtually. Recently, the Office of Court Administration launched the Public Safety Report System on April 1st. The Public Safety Report System was part of bail reform that was passed during the second special session last fall. It compiles a report that contains the defendant's criminal history along with whether the individual is eligible for personal bond and provides other information for magistrates. Magistrates must use this in setting bail. In addition, the bill also requires judges who set bail to receive 8 hours of judicial education. DPS is also requiring anyone that queries the system to have 8 hours of training, DPS training. And if you're just looking at criminal history, you have to have 4 hours of training. So many of our judges are looking at least 12 hours of additional training just on criminal history and bail this year. Part of the bill also requires OCA to post on our website a completed bail form. So the bail forms have the defendant's name, what they were charged with, what their bond amount was, and who set the bond. And we are required to post those on our website. I just looked this morning, we have over 55,000 on our website. And so you can go on there and search for a defendant. You can search for a location and find information that way. And that's all required via Senate Bill 6. Also, we're working on a uniform case management system. This was from the 86th legislative session, and part of having uniform case management system is going to help with reporting and collecting case level data. So the system is focused on counties under 20,000, which is over half of the counties in our state. We have 40 counties that have identified that they want to be on the system. We're hoping to have the first 2 counties on later this fall. It's Crane and Brewster counties. And it's really going to help once that system is complete and we have more counties on, it's really going to help with the judiciary's effort to collect case level data, because if a county or jurisdiction doesn't have a robust case management plan, they can't report to the state. Like I said, I was at Judicial Council this morning. This was the first time the councils met in person in over 2 years. The council has 4 committees this year covering civil justice, criminal justice, data, and public trust and confidence. Most of the recommendations that come from the Mental Health Commission will probably be routed through the criminal justice or civil justice committees. The council's been charged with studying several issues this year, including remote proceedings, court backlogs, and collecting case level data. I also wanted to let you know that we recently published our fiscal year 2021 annual statistical report. It's on our website. I encourage you to look at that. There's a wealth of information, and there's information on mental health filings in our state, and it's a really good resource that I encourage you to check out. Answer any questions you have.
Well, I have a lot, but it's thick all day. Anyway, I think I appreciate that, Megan. We have some announcements from some of our partners. So Lee Pearson.
Oh, he is not here. He wanted us to announce, yeah.
Oh, they have a ribbon cutting ceremony today in the Dallas County Detention Center. Open today. Okay.
Yes, so the big news is that it opened today, that they imitated, I think, the Harris County, and they're very excited about it.
Okay, great. Adrian Kennedy.
Thank you. Yesterday, we had a smaller meeting in terms of strategic planning for the Judicial Commission. And Christy was asking a number of us, or a few of us, to comment on where our organization stood and what we were bringing forward in terms of what our history had been, what our action plans were, and what new topics and themes were kind of rising up and strengthening in our particular areas. So I happen to have shown I had one copy yesterday. Well, I have 45 copies today because I was lucky enough to have NAMI in Arlington, Virginia, FedEx me 45 copies. So not pressing this on anybody, but if you're interested to see kind of the careabouts and the focus and the development that NAMI has taken in the last, particularly in this time with COVID impacts and the impacts of mental health across the country, but also in terms of adjustments that are being made to priorities and diversity, equity, and inclusion priorities around treatment care and health. NAMI's tagline in this area has been help, not handcuffs. So I thought that you would like to see what we're doing, what NAMI is doing in that direction. And I also want to say that it's because actually of the intense momentum that was created in Texas around judicial issues and mental health and the Texas Judicial Commission on Mental Health. NAMI absolutely made sure that judicial systems were part of the focus and part of the high priority of keeping track and keeping connected and really, what we've heard about building relationships so that we understand, more and more about how we can collaborate and work simpatico in all of this. So I only took out about 10, but I promise you I have 30 more in a rolling backpack that I rolled into. So it looks like this, not pressing on anybody, but if you'd like it, you'll see what NAMI's been up to in 2020 and 2021. This is the annual report. Thank you.
Thank you. Jim Kazin.
I've been asked to make an announcement as to AOT. So next at the conference that we're going to have in November, we're actually going to have an entire section on how you set up these types of programs. And by these types of programs and court orders, you all know that we have all the criminal diversion going on in criminal courts. AOT fits some, and these types of courts fit that component where you're diverting people into a civil court, either to avert inpatient hospitalization or jail. And thanks to Professor Shannon, the Treatment Advocacy Center, and several other individuals in the field, about 6 months ago, I promised you we'd have a manual. We got one. It's all printed, ready to go. It's now on your website for the Judicial Commission. It's about 100 pages long. It will walk you through every aspect of how one of these works, what the myths are and aren't, as well as how to maybe think about using it as a diversion from jail or criminal offenses. So we're proud of it. We hope you guys can use it. And I hope you'll attend our little breakout session in November.
And on behalf of the criminal justice system, anything we can ship to the civil side.
That scares the heck out of the probate judges. Probate courts are not criminal courts, but we can have a function that can help. So.
And Judge, aren't y'all hosting in San Antonio the conference?
Oh yeah, we're having the national AOT conference in San Antonio this October. And it's all across the nation. It started here is really just, or in other states as well, but I mean, it's really taken on its own cadre, and courts from across the nation will be visiting us in San Antonio. You're welcome to attend as well. Thank you, Brian. I forgot about that.
Thank you. Dr. Keller.
Apparently only people whose last name begin with a K. So I'll be super quick since we're fast, but I just wanted folks to know that some of you may have met Yolanda at the Southern Regional event, but Yolanda Lewis is our new head of our health and justice area. Yolanda came to us most recently from Pew Charitable Trust, where she headed up their national justice portfolio, which included way more than just mental health. And then before that she was the administrator for the Fulton County, basically Atlanta court system. So she's coming in and she basically is doing what John Petrola was doing before. John Petrola is now doing part-time. Some people say it's because he got a place in Santa Fe, but I actually think it's because Yolanda's here and he finally feels like there's somebody who could take that on. And then Yolanda was apparently born under a lucky star because her first hire that she got to help her with health and justice stuff in Texas is Tim Bray, who's sitting behind me. And so Tim, who did a wonderful job, apparently was a commissioner here, right? For almost 10 minutes before one meeting, is now helping on that side. So we're really thrilled to have Tim on the team. And the last thing, just so you guys are aware, John Snook, who had previously been at the Treatment Advocacy Center, really involved obviously with AOT stuff over the years. We just promoted him to our Chief Policy Officer last month. So all of these folks are in position to just be an additional resource of supporting this work. And ultimately you all are actually doing this work. So we're happy to be helpful as we can.
Thank you. And Professor Shannon, your last name does start with a K, but.
Shannon. No, a K name too. So just real quick, we had our mental health law symposium on April 8th, I believe. A webinar some of you were able to attend. We had over 500 people Zoom in that day. We were sorry we could not have accommodated that many in person. So it was exciting as an educational opportunity, but several commissioners participated, spoke. Dr. Keller, that's the K tie-in, Chief Standridge, Beth Mitchell, and I were at the morning session looking at more Texas-y issues. Then the afternoon, we had Judge Leifman, Ken Minkoff, Professors Slavagan and Bonnie, Judge Mack, Dr. Penals from Michigan, Elizabeth Kelly, who's a leading criminal defense lawyer, has an ABA guide out. I add that because if you would still like to see it and get CLE credit, it's on our Law Review's website, the video as well as the PowerPoint presentations, and send Christy the link and send that around. Some of the fun things in the afternoon is Judge Leifman and Dr. Minkoff talked about the opportunities, the efforts of trying to redesign and modernize civil and criminal pathways to improve access and services for people with mental illness. And that group I've been a part of and the model proposals should be delivered, I hope within the next 4 or 5 months. COVID sort of slowed that process down, but end is in sight. Or the beginning, because people can take them and adopt them.
Okay, with that, we are adjourned. We're going to meet again in the fall. We're still trying to work out the date. It won't be until September, October. We'll get that date. We'll send it out. Thank you all so much. Travel safe. Oh, sorry.
And thank you from our part too. And please stick. So please.